Good evening, chat. Hello, guys. Tonight we've got a little bit of a short one because tonight we're going to keep working on the J Rock's Dragonfly. But first, we're going to start with the appeal of Trump's $485 million judgment that he received out of New York for the civil fraud trial. Now, if you guys don't remember, Letitia James, is part of her bullshit campaign against former President Trump, charged him with multiple counts of fraud. And there was fraud in the civil context, not in the criminal context. And what was the context of it? It is that Trump had used fraudulent means and inflated the value of his property, such as Mar-a-Lago and other holdings that he had, his own bank accounts and other instruments of assets that he used to secure loans and mortgages from banks and private investors. And the state of New York is claiming that that was fraud. It's interesting, though, because nobody lost money, and that's typically what happens in a fraud. In addition to that, nobody feels like they got defrauded. Everybody was okay. Everybody made money, and everybody wanted to keep working with Trump and his organization. But Letitia James decided that was fraud. Now, was it really fraud? Who knows? During the course of the trial, and I know some people had a bunch of questions about it. We didn't get to see the whole thing. We only saw bits and pieces of it. Trump was not entitled to a jury. It didn't matter because nobody asked for one, but it appears that he was never entitled to one anyway under New York law. So it was up to Judge Arthur Engoron to decide what happened. This is the judge who decided that, Mar-a-Lago is only worth like $5 million or whatever it was, like $18 million, when literally next door there are estates a fraction of the size worth more than Mar-a-Lago. If you guys remember, that's the type of situation we're talking about here. Yes, Nick Dev, you're right. Mar-a-Lago is really only worth $1 million. Yes, Mar-a-Lago is really only worth $1 million. Now, could he have theoretically defrauded investors and banks? Sure, he could have, but it clearly was not the case. That said, though, Judge Engoron decided that he had defrauded. We're not really sure who, but as a result of these alleged crimes, these perceived crimes, these perceived slights, he was fined, and the judge decided to fine him $365 million. In addition to that, there were multiple restrictions on the Trump Organization. The Trump Organization from that point on for the next 3 years, beginning this year, was going to need a independent overseer of the organization who would make sure they're not defrauding anybody. Trump was banned from running organizations in the state of New York. And also, not only he was liable, but his children, Donald Trump Jr. and Eric Trump, in addition to a couple of the executives in the Trump Organization, were found liable themselves for up to $1 million apiece, roughly. So that's where we are. This is also the issue where Trump was trying to get money put together, and the courts of appeals got involved and said, look, we're not going to force you to put all the money up. Judge Engoron was demanding all the money to be put up front for Trump to appeal. A lesser amount was ordered, so Trump did secure it with a lesser amount of money. But as of right now, with the interest running on this judgment, it is over 400. Actually, it's not even 485. I'm wrong. It's almost $500 million at this point. So, yeah, that's where we are. So yeah, that's where we are right now. Trump did appeal it. This was appealed to the First Judicial Department, Appellate Division. And it's very funny because this thing right here, chat, the background you see, minus, I included the guns and the pile of money and sunglasses, but these kind of the angels of justice, the guardians of justice, that is a mural that was painted in their building. And I forget where I found this so many years ago on Google, looking around for like murals and courthouses. This is the one I found. It's kind of funny that it happened that way. So yes, this is the place we're talking about. Also, I wanted to mention, guys, we're live on Rumble tonight. I finally got Rumble to work and also got out to doing it ahead of time. So guys, Rumble should be working. If you're out there, try Rumble. Build me a tower over there. Build me a church. Oh. Now, Kat, you're asking, did the appeals court overturn the case? Not yet. These are the oral arguments. It's only a half hour long. It's 15 minutes each side. This was held September 26th. So we're just now like just over 2 weeks since it happened. It's going to be months. It's going to be months and months and months down the road. And the funny thing is, just like Trump's criminal case, it's probably going to get overturned. This is going to get overturned. But the damage will have been done because this is all lawfare meant to bog down Trump before the election. Because afterwards, if it gets overturned, they'll go, oops, I guess we were wrong. Tee-hee-hee-hee. Not acknowledging fully that they did this intentionally to screw with the election. So, Michelle says, which court do I have a pick? It should be this one. So that's the background that I have. That's where I pulled this out of, is the First Appellate Division, or the First Judicial Division's Court of Appeals. Now, this is the intermediate court, chat. So there was the trial court, the Supreme Court of the state of New York. Now there's the First Judicial Division's Appellate Court. Then the next stop from here is the New York Court of Appeals. The New York Court of Appeals is their Supreme Court. You would interpret in every other state as their Supreme Court, their highest court in the state. That's the next stop, but let's hope it doesn't get that far. David, MLS Law, how you doing? I want an opinion. How are you doing, David? I hope you're doing well. Oh. James Jam says, hasn't this been going on for years? The case was going on for a couple of years. It drug on a little bit. But no, this is all pretty recent still. Because remember, the verdict and all that stuff at Judge Engoron's case happened in the beginning of the year. Now, just when we start this, you're going to hear some names and see some names that are familiar. The attorney arguing on behalf of Trump is Dijon Sauer. And that's the attorney who argued the Trump v. United States case, the presidential immunity case. So Trump is tapping that guy again, retaining him for a little bit of that, get him on a winning streak, get him when he's delivering the big wins. And are you going to cover the Whitmer stuff? Which Whitmer stuff? Are you talking about the Whitmer guys getting arrested and their convictions? Yes, we'll talk about those. If there's something else Whitmer-wise, I don't know what you're talking about. Luke says, you could tell because his voice is fucked. Oh, yeah. Yes, the guy has a weird voice. The guy does a very weird voice. Sunseal says, Dijon Sauer? I didn't even know mustard could go bad. Hey, as an experienced sandwich maker and a patrician of the sandwich arts, as some people have labeled me, yes, I know my mustards. And yes, Dijon mustard can go bad. Oh, the Dorito video. Oh, God, that was so cringe. But hey, you know what? I will say those women were eating Doritos in a more manlier fashion than Nick ever could. They fit the whole thing in their mouth and just went chomp. They didn't nom, 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 nom with it. So I will give the women credit. They did it right. And Maddie, I saw you up here, dude. Sorry, Maddie. Sorry this year about the sorry about the Tigers, but don't worry. I'm going to go on to hating the Yankees now. If you guys weren't aware, the Cleveland Indians, put in that work today, 7-3 against the Tigres. Now they're going to go on to destroy the Yankees. It's going to be great. We're going all the way, chat. Scam likely says avant-garde obesity. Yes. Oh, yes. Ag says they look less gay than Tim Walz. Yes. If you guys didn't see this, we might as well look at it real quick because it is funny. Tim Walz struggling to load a shotgun while he's out pheasant hunting, which I will point out he looks, believe it or not, like, I've it's been a little while since I'm not tromping through the woods in the next, anytime soon. A little fat for that, but my hunting gear, it's been used. It's been well used. And it's got, evidence of use. It's got mud and blood and crud all over it. And this is Tim Walz fucking around with a Beretta shotgun. Now, if you listen to him, he says, "Oh, I've had this forever," and it looks like he just got it out of the box. So here we go.
Yeah.
And also, look how nice and bright and clean his orange is. I mean, at least this guy here, it looks like he's worn it a couple of times. But geez, Tim looks like he pulled everything off the rack, which he probably did.
And it never fits quite right. Never fits quite right. Just not quite right. How do you give it back?
Governor, what kind
And this fucking shotgun is kicking his ass.
of gun is it?
This is a Beretta A400.
I can't even tell what the fuck he did that he's having this much trouble. A Beretta A400 is not, it's not foolproof, but God, he must have boogered something up really bad. And I don't know what he did.
I bought it when I was shooting a lot of trap because it has a kind of their patented thing, a kickoff. So when you get old, it doesn't hurt your
Their patented thing, a kickoff? You mean recoil absorption? Okay, Governor.
shoulders much.
Yeah.
That's my theory. And it never fits quite right.
Now you guys are making fun of the chaps. That's actually normal for, like, if you're going out in the woods and you're going to briars and brambles, keep shit off your pants. It's like Carhartt like material a lot of times, or like a canvasy pants, like a chap you can wear that keeps shit off your pants. Also keep some mud and blood and crud off of them, but I was never that fancy. I would just wear a pair of jeans and, you're going out, you're hunting pheasants, you're not hiding from them. But I mean, he's wearing his vest and he doesn't even have like pheasant blood on it. And if you guys aren't aware, right here in the back, that big curve in his orange, if you've never hunted pheasant before, that's actually not sewn in. That's a panel, and it's kind of like a little backpack you could shove pheasants in. You shove game in as you kill it. So it's interesting to note this looks like it's never been fucking used at all. So, yeah. Yep. So there you go. People always talk about hunting. Well, there you go. We talked about hunting. Yes, basically it's a pocket. Yes. It's the poach pouch. Well, oh. Yes, you can put rabbits and other stuff in there too. But usually I'm not like, I've never killed that many rabbits where I'm like, usually you get a couple, but not a ton. Urban Decay says that's not Minnesota, is it? Because there really isn't brambles or stickers or anything like that. I've never dealt with it, at least in 30 years of living there. I don't know, Urban Decay. Maybe. Not sure. Porcelain Thunder saying he was in the military for 20 years and he handles a gun like that. Okay. And that part I don't think is a fair argument. There aren't many times in the military you're handling a semi-automatic shotgun. Unless you're like in a special mission unit. Otherwise, he would never have touched one in his military service. So, no, I wouldn't. Like, you couldn't give that gun to a normal, like, a lot of people might not be able to operate that. Why is Tim Walz so unlikable? Well, it kind of goes to the idea he might have been like, he might have done, like, he's just a horrible fucking human being who allegedly took, like, one of his students to a concert and maybe to a gay bar, but that's kind of all been alleged. But that might be the big October surprise that Tim Walz might like little boys' balls. Sounds like that's coming. Yes, he could fit 3 or 4 boxes of tampons in that back pouch. That'll be funny. We need to see Kamala operator Glock now. Yeah, I don't know. I heard Glock. Yes. She got a Glock and Forte. Oh. Axe says they have pump action shotguns though. No, they don't. He said it's a Beretta A400, and this is a Beretta A. This is. I'm assuming he's correct at the type of, like, the brand, but if you look, that is not a pump action shotgun. That's a semi-automatic. That's a semi-auto shotgun. So that's a semi-auto, man. That is not pump. Jariah is saying, you may have answered this, but what are the odds that lawyers get censured for this? In the Trump case, are you talking about making the arguments? They're not going to get censured. These are valid arguments and valid appeals, so they won't have any problems. Yes, the majority of the population can't afford an A400. I hate being poor. A400s are beautiful shotguns, though. They're amazing. Yeah, yes, does Kamal's Glock have a switchy? That's the real question. That is the real question there. Yes. Oh, that was oh. Let me see here. And then he's also semi. Yeah, well. Trump once said those could be odd to load. I guess, but I just assume he doesn't actually ever handled one as part of the issue there. It's like it's back in like 2012 when Obama, they took a picture of him shooting an over-under shotgun, and it had like one choke in the top barrel, and there wasn't a choke in the lower barrel. It's like they clearly just threw something together and said, here you go, Tim, go wander around on a photo op. So, yeah. That's why, like, if I did it, I'd be using, I take a gun you actually own that you can operate, so you don't look like an idiot. Italians make better shotguns in their cars. Yeah, well, the Italians have been making guns for almost 500 years at this point. DK Cripple says, "What's a switchy?" A switchy. It's you put it on the back of a Glock. It's switchy. These things right here. What these kids are using that make it full auto.
Switchy. No talk. No cap. No talk.
Those little things on the back of the pistol, you put it on the back and you flick the button one way and you get burnt. Makes your blicky full auto. Makes your blicky full auto, as the kids say. You got your blicky with the glizzy. You get watch your glizzy with the switch. One Eye Moon says my rifle is Czechoslovakian. It's your favorite clip. I love it. It's a great clip. It's a great clip. Yeah, A400s are $2,000 to $3,000. That's inexpensive for a game shotgun. Well, my game shotgun's a 20 gauge 870, man. Yeah, I've had it now for like I don't know, like almost 15 years now. Like, that's my shotgun, dude. Like, yes, I mean, you can buy semi-auto shotguns that are a little less expensive. But I mean, for a lot of people, $3,000 is a lot to sink into a gun they won't use all the time. Krieghoffs, yes. Okay, yes. If you're using like a Krieghoff, but I wouldn't take a Krieghoff out doing upland bird hunting. A Krieghoff is like, that's meant for like on the trap field or sporting clays. And I'm not even sure I'd take a Krieghoff out doing sporting clays. My buddy, though, one of my friends, he has a Krieghoff over under. Oh my God, that thing is like waving around a pillow. It is so light and very nice. Yes, no cap. Oh my gosh, you guys are so funny here. So we're gonna get started right now. Oh, hold on here. What are you asking? Cat says, "Don't laugh at me." What does no cap mean? No cap means telling the truth. That it's you're telling the truth. You're giving the straight dope. Whereas cap means lie. And I don't understand what that means. So yeah, no cap means the truth. 10 gauge or you're a chick. Why are you fucking using 10? Why would you use 10 gauge to hunt pheasants? You hit a pheasant with a 10 gauge, it's gonna go poof. It's like an exploding pile of feathers. Oh. Stoker is a sweet point with cheap and reliable semi-auto shotguns. Yes. And I think there's also, for a while, they were marketed under the TriStar brand. That's another bit of the Turk Roach imported shotguns, but those are, yeah, Stoker is like the bottom end of where you would willing to go. Shredder says, I'm a Remington man as well. 870 is a great gun. Yeah, at some point, though, I'd like to get like a nice, set of like over-unders. I'd like to get a decent over-under at some point. It's just there's something about, and I know people who aren't gun people won't get this, but when you have used a very nice shotgun, it's kind of like using a really good scope. Like there's a difference between a $500 and $1,000 scope and a $5,000 scope. Like the amount of quality is day and night. When you have a shotgun, that's been custom fitted, because you can get shotguns fitted. They use, it's called a tri-gun, and it's like getting anything else tailored or bespoke. They set it up and they get it for your height and your length of pull, and they set it up for you. And you can tell the work that gets put into them. But a very nice shotgun, you can tell you're holding something really cool. There's been times where I've held a shotgun and I'm like, I feel like I need to wear a tie and have a flat cap on if I want to go use it, because it's just that nice. But yes, an 870 is great in the meantime. So is a Mossberg 500. Yes, dead ass. Yes. Yes. Why would you use a 10? Because you can't find an 8 or a 6? Well, yeah, why don't I just use a punt gun to hunt pheasant? Oh. Kitsaki says 20 gauge or 410. I have a 20 gauge 870. I could see using a 410, but that'd be really hard. That'd be really tough. I don't think that would be wise to do, but there's also like 28 gauge people have used. Like that's kind of on the I mean, it's when you think of like a 410, it's like, hold on, what's a 410? It's like, I remember reading this once. If you were to do it by gauge, it's almost like a 67 gauge shotgun or like a 70 gauge shotgun. So like, no, I think 28 gauge is probably like the bare minimum you'd ever want to do reliably and be safe. Das Boot says TriStar and Stoker are owned by Beretta. Yes, they are, but they're imports. So Stink Pliskin says, isn't Remington out of business? I think they're kind of like on and off. Sounds like you've spent a lot of money on a very good pen. No, I can't do very good pens. Like people like when I was getting ready to graduate law school, I was like, don't buy me like a Mont Blanc or anything like that. I'm going to fucking lose it. I lose pens all the time. So no, buying pens, no. I've used very good pens and I've written with very nice pens and calligraphy pens and very fancy ink pens, but no, I can't use them. Also, I chew on things a lot. They call it an oral fixation. Like I chew the shit out of everything. Hunch says, now substitute shotgun for crack. Yes, there are a lot of people who will say that about things there. Hold on one second. I wish we still get Sega 12 and Vepers. Well, you can get the Chinese ones. What do you guys? Oh, Steve Gosney, how you doing, Steve? We're gonna get started with the Trump oral arguments here. So, if you'd like to join, I can send you a link if you're interested. But it's up to you if you're interested at all. So here we go. What's the smallest gun I own? Like the smallest would probably be like in size. Like I know my Remington, the 22, the Remington 67 I have, the Great Depression era 22 I have, it's pretty small. It's basically like a cricket, before there was a cricket, but I own like a Star BM. That's pretty small. So I own a Derringer. No, I do not. Floodbusters attack Daisy on Twitter for no reason. Well, that's no good. Oh, well. Matt sometimes picks targets of opportunity for himself, so that's all his post. That's all his op. That's his right. Here, let me. Here's the link for. Yeah, all right. Hey, Steve, I just sent you a link if you'd like to join. All right, guys, so enough talk. We're burning daylight here. Let's get going. This is time for the appellate arguments for Trump versus the state of New York. So here we go. All right. Crank up the sound here. Okay, so here we go. Now, as common with oral arguments in appellate cases, guys, this isn't the only one they're hearing. So that's why you see like an hour-long thing. This is not an hour-long oral argument. There's two separate arguments they're having. So here we go. There are five total judges that are going to be coming out. Yeah, we'll go from there. So here we go.
Please rise. Justice of the Appellate Division, Supreme Court, First Department. Hear, all persons having business with the Appellate Division join here to the attendance, and you shall be heard. Please be seated.
Good afternoon. Welcome to the Appellate Division, First Department. At this noon calendar, we're going to hear the argument of the state of New York versus Trump. When you request your time, please understand that we have the record, we have your briefs, all of the briefs, and we're familiar with the facts of the case, so ask for the time that you need to make your most important argument. I'm going to ask now.
Well, yes, Steve, they're basically arguing this is excessive, and also they're just arguing that the judge, like there wasn't enough evidence to support this, but also that his determinations were absolutely insane and that he abuses discretion. So this is almost kind of like an excessive fines thing, yes. But it's like everything was wrong in this case is what they're arguing.
For the appellant to rise and tell me the amount of time that you would like for argument. You can do either way.
The court previously granted my colleague John Sauer co-op permission for the brief from this morning or this afternoon. At this point, if you'd like to ask the court's permission for the
Your request motion is granted. The time?
Time, Your Honor, we'd ask for 15 minutes, 10 minutes in opening and 5 minutes in rebuttal, if that's
Okay, 10 and 5.
Brian Isaac, I represent the non-party appellate. We usually only have 15. Could I just get 3 and 2 on this?
Thank you very much. Won't argue with that. 3 and 2, 10 and 5, yes? So we have a limit of 15 minutes. If you want to, do you want to split that so that you have rebuttal time?
As the appellate, I mean, we'll just take a full 15 minutes. I guess I wasn't quite sure how to divide it for Don's party.
Okay.
You guys are funny. It's not a
All right.
portal.
And you represent
The state.
the state, right? So you,
Maybe one way to do it would be 15 for the main appeal and 2 for the other.
I would think that you should
In total, that is most of the time.
So you don't want any rebuttal on either one?
Oh, I'm going to take rebuttal, Your Honor.
So why don't you do 15 and 2? I'm sorry, 13 and 2. Okay.
Hey, Steve, how you doing?
You would? Yes.
Good.
Okay, guys.
Good.
So,
How are you?
and I'm doing well. I'm doing well. But yeah, this is an appellate argument, so I thought this would be like right up your alley. So,
well,
guys,
it is actually.
Oh no, I was just explaining to everybody, guys. You heard these people talking to the judges about time, and that's because you have time to present your argument, then you have time to present a rebuttal argument. So that's why they're asking how they want to break it up: 10 minutes, 5 minutes, then 3 and 2. You also heard as well. So
you have a 15 total. That's the same in Florida too. It's a typical state court time limit.
Yeah, yeah. And guys, the reason why they asked Trump to break his up is because this is his case at this point. So he gets to end with the rebuttal argument. So he goes first for 10 minutes. The state of New York goes for 15 minutes, and then he finishes up with 5. And so that's the argument they're making there.
Yeah, just to give a little framework, I have an excessive fines case pending before the U.S. Supreme Court right now, which is the one on prisoner incarceration. And so I'll be interested. The reason I'm tuning in here is because I'm very interested to see what this court does and how they apply it. The leading U.S. Supreme Court case is a case called Bajikakan, which is authored by Thomas. And basically allows for the framework of, is it a fine and is it excessive? And excessive goes to proportionality. And I think there's this to me, this fine is very, very excessive. So I think they're going to, there's going to be some traction here. So we'll see what they are.
Yes. And Luke, I got confused. Sorry. I thought you meant, were the attorneys in this appeal going to get sanctioned? It's like, well, no, because they have the right to file an appeal. Yes, there were sanctions handed down by Judge Engoron as part of the trial, and they're arguing those. Yes. I'm sorry. I thought you meant, is John Sauer going to get charged for having the gall to file an appeal? No, he's not. But yes, the trial attorneys are facing potential issues because Judge Engoron's a psychopath. So, and here we go, guys. Eric with the K, buddy, how you doing? Yes, it's not a fine, it's a tax. Well, this one was entirely this one definitely was a fine.
Well, the issue in the Supreme Court, the issue in the Supreme Court case that I have is whether or not, whether or not the excessive fines clause applies to costs of incarceration, whether the Constitution applies to that state cost. So that's what the issue is in my Supreme Court case.
Well, and I'm not going to lie. I always hate that idea of, well, we charge people for being incarcerated. Well, then why do they fund it with tax money is one of my first questions. But also, you're forcing me to be there, and now you're charging me on top of it. I think that is wholly improper to start with.
Yeah, and I've written a whole law review article on it. And actually I've been generating this argument because for many years, I don't want to interrupt your flow here, but you can find that article on SSRN also, which is, I'll post that on your private chat too.
Okay.
If you want.
All right. Yeah, we'll take a look at that at some point. But anyways, guys, here we go. Judge Engoron doesn't deserve his title. Well, sadly, he got it. So here we go.
Thank you, Your Honor, and may it please the court, John Sauer on behalf of the appellants. This case involves a clear-cut violation of the statute of limitations and the law of the case doctrine. Last year in Trump 1 at 217 AD 3rd, page 611, this court held that no liability could be assigned for transactions that were completed prior to February of 2016 or 2014.
Mr. Sauer, that that's premised on the fact that the statements of financial condition cannot give rise on their own to a new violation of 6312, right?
That is correct. That's what,
Then why didn't we say that in the earlier decision on the motion to dismiss when we were reviewing the motion to dismiss?
I think that's what the phrase, the continuing wrong doctrine does not apply to delay or extend limitations period means, because that is the continuing wrong doctrine. To say that like a 2017 or 2018 statement, is a new discrete wrong that's distinct from the original transaction that closed way back in 2012, that just is the continuing wrong doctrine.
You don't think it applies to Ivanka Trump's arguments on that appeal, or to the Attorney General's now discarded theory that there was somehow a large amorphous fraud that somehow told the statute of limitations all the way back to 2011? Isn't that statement applicable to either of those two arguments made on the motion to dismiss appeal?
Your Honor, if I understand the question, the dismissal of Ms. Trump strongly supports our interpretation of the prior opinion, because of course the allegations with her in the complaint are virtually identical to the allegations against the other individual appellants. So if you look at the complaint, you see virtually identical claims and theories as to those two. And once this court held she's not covered by the tolling agreement, she was completely dismissed from the case. The same should apply to anyone who's not covered by the tolling agreement here. And I would emphasize further, though, that there's really two errors here. Because even if the continuing wrong doctrine did apply, it still doesn't allow the trial court to do what it did, which is to go way back in time to 2011 and 2012 and assign liability and major consequences, huge financial consequences, based on an analysis that never looked at a 2017 or 2015 statement and said what liability flows from just that statement that comes much later in the course of conduct.
And loans which closed long ago.
Exactly right, Your Honor. And again, this court addressed this squarely in the Henry decision, which is cited in Trump 1, the CW Capital decision, which is cited in Trump 1. What Henry says is, even if you apply the doctrine, it only applies to allow liability for statements within the limitations period. But that's not what the trial court did here. That's not what the Attorney General's office contended. They said, oh, we're going to apply the continuing wrong doctrine. That contradicts Trump 1, so that was the first error. But then the second error is, once we've done that, we're going to pretend there's no statute of limitations at all. And we're going to go all the way back in time and assign crippling financial liability for transactions that concluded again in 2011 and 2012. So there's a direct contradiction, a direct disregard of the prior, this court's prior opinion. It becomes really clear, I think, when you look at, for example, there's a citation of the Yin-Shing Lung decision by the trial court. And the trial court says this shows this is a continuous series of wrongs, each of which gives rise to its own liability, when there was an opinion from this court 3 months earlier saying the continuing wrong doctrine does not apply. That makes it very clear.
But again, shouldn't we have said, or wouldn't we have said, these statements of financial condition that fall within the limitations period don't give rise to a 6312 claim? Shouldn't we have just said that? Would save everyone a lot of time.
I think that's clearly what the continuing wrong doctrine means if you apply it. And again, the dismissal of Ms. Trump strongly supports that. But in any event, Your Honor, even if the court doesn't agree with that, there's still a massive violation of the continuing of the statute of limitations. Because again, under Henry and versus Bank of America and under the CW Capital decision, the most the trial court could have done is looked at the 2017 statements and said, what liability can I assess to that? Can I oppose to that? And that is not at all what happened in the trial court. There was just a complete disregard of statute of limitations and an analysis that again and again goes all the way back to 2012.
Even if we agree with you on the statute of limitations point, that would not result in the complaint in its entirety being dismissed. There would still be several transactions that would be not time barred or timely. So what is your response to, or what is your strongest argument as to for dismissal of those claims, those exited non-time barred claims?
Right, there would be 2 of the 10.
Now, guys, they're arguing that a bunch of these occurred, as you heard him say, in 2011, 2012. Yes, that's right. Letitia James went all the way back. Yeah, they went all the way back to 2011 and 2012 for some of this stuff. And as you heard him say, there was already a prior Trump case that came through the courts. And they're just digging up and digging up, digging up. But that's a long look back window. And even for felonies, you don't get to look back that far, generally speaking. So
and the way I'm understanding his argument is that the misstatements occurred, let's say, in 2015, right?
Yes.
For the court to reach back before 2015 to establish damages.
Mhm.
So you're saying you're going to have damage for statements that weren't made yet?
Mhm.
That's a pretty
Well,
good argument.
There's also, but as the court has just pointed out, there are some of them that aren't time barred. There's some that would have been a timely part of a fraud case. So now they're asking him, okay, well, let's say I agree. And you're not in a bad position when the court's already starting to say, well, how would you distinguish these ones from that one? It's already starting, as people said, this was a little favorable to Trump based on the way the judges handle it. We'll see his argument about how do you handle the current ones.
That were charged in the complaint that we've identified that would only apply to those covered by the tolling agreement. Like Ms. Trump, if you're not covered by the tolling agreement, it's all gone, essentially. But in answer to your Honor's question, we argue that there was a complete failure of proof on the critical element of capacity or tendency to deceive, which is an element required of any 6312.
Well, if I can stop you there, are you talking about a failure of proof at trial?
Absolutely, Your Honor, as well as in summary judgment. So we raised this.
Okay, but cause of action number one, which is the fraud-based claim under 6312, liability on that was not tried.
Also, guys, this is John Sauer, Trump's attorney. I said it a couple times. I put it down on the banner so you guys see it's Trump's attorney.
Right? That was determined at summary judgment.
That is correct, Your Honor.
Okay,
And
so
so
I
we
don't-
challenge it as to both, yes.
I don't believe we can look at the trial record to answer any questions about the sufficiency of cause of action number one based on fraud. Don't we have to confine our review to the summary judgment motion record?
Well, to the extent that the trial court in the final decision was repeatedly referring to reinforce its prior holding in summary judgment, yes. Now, our position, of course, is that the failure of proof is even more defined, even more clear when you look at the summary judgment record. For example, just a couple citations to put this in context. Summary judgment record, page 13965 of the record, is a Deutsche Bank witness, uncontradicted, saying if his net worth had been as low as $1 billion, for example, he would have gotten exactly the same deal. It would have been exactly the same transaction.
Also, Maddie, I didn't answer it. I didn't see anybody ask it. So chill the jets just for a second here. The continuing wrong doctrine is the idea that a statute of limitations doesn't apply because you can chain it all together. It's one continuous action. So the fact that you kept the action alive, like if I do something and I keep it going for a very long time as a continuous act, it's still one whole action. It escapes the statute of limitations. So, well, I'm just saying, it seems like people are getting a little upset we didn't answer something. I didn't see it. I'm trying to listen and watch, so my bad. My apologies.
Yeah, it's tough because, well, this is, see, now you know what it's like having 15 minutes of oral argument.
Yes.
You know, you've had months and months of briefing and very in-depth research. And this is the thing. I know that like people sometimes watch my oral arguments and they criticize. It's like, you're all over the place. First of all, you're trying to make like 1 or 2 points in your 15 minutes, and then you're constantly getting interrupted by things you don't expect. And so you see he's talking really fast because he wants to get his thing. Plus he's in New York. So this is very what you see in oral arguments. I'm really not a big fan of oral arguments on appeal. I think it should all be in writing. But they do have it, and that's what we're watching. Most of the content of the legal argument is going to be in the brief. The appellate advocate here is going to pick 1 or 2 points that he definitely wants to make, and then he's going to have to switch, curve and duck and bob and weave to get out of the judge's file.
I hope that makes sense here. It's Maddie, think of it as an ongoing harm that never ends. And because it never ends, it's still alive. Therefore, there's no statute of limitations you can attach to it. If it's a continuous and ongoing wrong or a continuous and ongoing course of action, it never ends. And because it never ends, that's how you look at it. I mean, the continuing wrong, it's the continuing bad act. It never ends. Therefore, they're arguing because we can go back as far as we want because of the continuing wrong doctrine. And they're pointing out even this very court, the court they're in front of, has said, no, that's not how you can do this. And they had done it before Judge Engoron had even made that determination. So, I didn't know it was being argued. That's okay. That's fine. If you guys don't know, don't be afraid to say. I'm trying to read. I'm trying to listen too. So if you don't be afraid to ask, like, 2 or 3 times. Be happy to answer it. It's all good. But anyways, let's keep going here. Continuing's like the Clintons. Yes.
That's uncontradicted.
Yeah.
Exactly the same deal. It would have been exactly the same transaction. That's uncontradicted. It's reinforced by the trial testimony.
But could the trial court have credited Mr. Hayes' statement? He's also a Deutsche Bank employee, correct? And he said that if the facts were, if the SFCs were incorrect, then they didn't properly assess the risk on these loans. Mr. Hayes said that. You would say that in your brief, I believe.
He made a much more generic, if you look at that particular citation, he made a much more generic content that we want to make sure we're being, compensated for our risk. What is not disputed is the testimony that if the net worth had been as low as $1 billion, and again, this is the testimony of Williams, if the net worth had been as low as $1 billion, the deal would have been exactly the same. And so it's astonishing if you look at, for example, page 1882 of the record, which is their schematic that they cite 9 times in their brief, they concede that President Trump's net worth ranged between, on their view, $3 billion and $4.7 billion throughout this entire period, which is miles above.
If you're talking about summary judgment, isn't it basic that you don't make credibility determinations on the motion?
Absolutely correct, Your Honor, and we have a repeated violation of that, as we point out in our briefing. For example, there's sort of kind of astonishing credibility determinations to disregard.
Now, remember, chat, with summary judgment, it's based upon all facts available, and you assume all facts in the light most favorable to the non-moving party. Is there any disagreement over the facts in this situation? Are there any differences of fact? If there's not, then you can apply the law, and the court can apply the law. Well, if the court is determining the credibility of a party, then there's an issue of fact, and that means it has to go to trial. But as they're stating here, the judge shouldn't be making determinations of credibility on the summary judgment.
Or if, for example, Trump is putting forward experts and putting together affidavits and summary judgment in support of summary judgment, the judge can't discount those affidavits when they're unrebutted. So what he may be arguing here is you have an unrebutted affidavit by a Trump affidavit, right? And then the judge says, well, I don't find that credible. But see, that's not his position. He can't make that credibility determinant in summary judgment. The only question is whether or not there is rebuttable testimony, whether there is a genuine factual dispute. So,
Yep. All right, guys. So here we go. We're going to keep going here.
Unrebutted in the summary judgment record, expert testimony. So if you look at 17-916, the summary judgment affidavits of Bartoff, where he explains how all these representations, virtually everything they challenge, is consistent with generally applicable accounting standards. They're GAAP compliant statements. That's unrebutted in the summary judgment record. It goes beyond merely being disputed and you couldn't decide it by a credibility determination. There's really nothing to the contrary. And again, these errors are all reinforced at trial, so we are challenging both of those. And if you look particularly at Professor Bartoff's testimony, you have this clear explanation that all the things that they say are misleading are things that are specifically approved in ASC 274.
Creating an issue of fact, correct?
Exactly right, Your Honor. That's exactly right, Your Honor. That's at the very least, that's a disputed issue of fact. It isn't just Professor Bartoff. There's a whole series. There's Professor Flemons. There's a whole series of experts. When you get to, yes, Your Honor.
Well, you finished that, but then I have a question for you about the scope of the statute.
Go right ahead, Your Honor.
Okay. Yeah. No, so just looking at the language of the statute, it says that it's enacted to promote the honesty and integrity in commercial marketplace in New York by stopping fraud and illegal business. So to accomplish this, the statute authorizes the Attorney General that whenever a person shall engage in repeated fraudulent, I know that you're challenging that, or illegal acts, that they can bring such an action. So why isn't the language of the statute here referring to the repeated and fraudulent illegal acts or persistent fraud or legality? Why doesn't that define the scope of the statute? Why do we need to go to harm or threat of harm?
Yes, Your Honor. So the standard is that, as this court held, for example, in General Electric, is there has to be a capacity or tendency to deceive or atmosphere conducive to fraud. And what we've pointed out is that you have a situation where there were no victims, no complaints, no evidence of causation, materiality, or reliance. There were sophisticated counterparties who the understanding of the relevant marketplace, as this court said in the Nordbank decision, understood that they would be doing their due diligence. They did do their own due diligence. The uncontradicted testimony in the summary judgment record is everything we did was independent. We didn't rely on the numbers. That's the Williams testimony in the summary judgment record. All that is evidence, for example, the Domino's Pizza decision that we've cited powerfully makes this point, where all of that is lacking. All that is powerful evidence that there was no capacity or tendency to deceive, which ties into our point that every single
What about
one of these
the issue?
transactions would have looked exactly the same.
I'm sorry, counsel. What about deterrence? In other words, the AG would have the argument that maybe these deals went down fine as far as all the parties were concerned in these deals, but in the future, some deal might not go down well, and someone would be harmed by that. And so we need to deter parties from putting in, fallacious statements of financial whatever. Good.
May I respond?
Yes.
Red light. Just to answer that question, the deterrence interest goes entirely opposite direction, where we have a situation where the Supreme Court disregarded unrebutted expert testimony that these are GAAP compliant. These are consistent with accounting standards, which don't require perfection.
No, but the Attorney General points out that whether or not they're consistent with GAAP principles, it's the factual inaccuracies that are important. So, in other words, you might be following GAAP principles, but if your data is terrible, then you're creating a fallacious statement.
Respect to that completely it disregards or at least misinterprets our expert testimony, which look at what they say is factual data that's misinterpreted. For example, appraisals. Essentially the Supreme Court said if you got an appraisal in your file, you got to rely on that. You can't rely on your own independent judgment. They say that's a factual inaccuracy. GAAP says the opposite. At least that's the unrebutted testimony in the summary judgment record. And I would direct the court to page 17916, the beginning of Professor Bartov's summary of opinions.
I want to turn your attention to a different subject.
Yeah, sure, go for it.
Yeah, GAAP is general accounting principles.
Yes.
And so they're saying that, and so it sounds to me, and I'm jumping in here, it sounds to me like there was a summary judgment motion, and there was an appraisal of a property, and that appraisal met general accounting principle practices, right?
It did.
And so that was unrebutted. So then therefore they should be entitled to summary judgment. And what the lawyer is here is saying, you can't just say, well, I disagree with that, because the expert testimony is that it complied with general accounting principles, and there was an appraisal, and there was no contradicting, rebutting evidence. There was no issue of fact that was contested. So the judge can't come in and make credibility determinations when those facts are uncontested. That's a very good argument.
Yes, and that's the thing. He can't say, well, I'm disregarding that fact. Well, no.
Generally accepted accounting principles. There we go. Your chat's killing me. Yes, that's correct.
Yeah, and so he just ignored actual accounts to make his own decision. Yes,
that's
the state couldn't contest it, and Judge Engoron said, well, I don't think that's accurate. If the other side doesn't present facts to contest it, you have to accept the facts presented.
Right.
So,
because the judge is not the fact finder in that position. The job of the judge in a summary judgment motion is to determine whether there's a factual dispute.
Yes.
J-Rock, buddy.
Which
He's just funny. We will not tolerate lawyer misinformation around. I'm kind of coming here as a student and bystander here. This is fascinating, but I'm just trying to making sure that we're slowing it down, because this is a fast argument, right?
Yes, this is pretty fast.
What's your time? Your red light is on. I'm trying to figure out about the valuation of Mar-a-Lago. I noticed that your expert, Mr. Moans, valued it at over $1 billion. He also said that if it was in the hands of a new owner, club memberships, 500 club memberships could be sold, generating $250 million, and it generates revenue of over $50 million a year in 2022 and 2023. And Supreme Court values it at $18 to $27 million because of restrictions. Do you have anything to say about those restrictions taking it down in value to such an extent?
I'd say two things in response to that. First, The Shubin affidavit directly addresses that. That was improperly kind of
He
disregarded.
says there are no restrictions on it. He says there aren't, Shubin says there are no restrictions.
He says you have to interpret, he says the trial court looks at one document in isolation, the deed of conservation. Mr. Shubin says you got to look at all 5 documents, including the historical practice there, to understand what the actual policy is. And for example, they say you couldn't value it as a private residence, but he's been using it as a private residence since 1995, continuously to this day. But the more fundamental point is that valuation, where he relied on a tax assessment, illustrates the hazards to the marketplace as a whole here from having the Supreme Court cite things like Chico Marx and footnote 9 of the summary judgment position, the I know it when I see it standard from obscenity law from Justice Potter Stewart to decide what's a misrepresentation in these statements. When you have expert testimony unrebutted that says these are gap consistent, if we have a system where you can issue perfectly accounting, clear and basically statements that comply with gap, and you're held, well, we have another standard. I know it when I see it. That's good. That's bad. People can't do business in real estate. So
Thank you.
thank you, Your Honor.
Oh, I'm sorry. There's another question.
And that's a very critical point.
Well, and
If we're complying with the law and the judge says that's not good enough, then what the hell good is the law?
Exactly. Well, and there's another, I mean, I'll tell you, I'm living in Miami and I'm living in South Florida.
Mhm.
Let me give you a concept, just a little taste on how ridiculous the real estate is here. Okay. We are looking to buy a house in a place called Coral Gables, which is a very nice area of Miami. Now, for a 2-bedroom,
I heard
1
Liberty
bath.
City's nice this time of year.
All right, get out of here. For a 2-bedroom, 1 bath house, 900 square feet, it's over $1 million in Coral Gables. Now,
Wait, how much for how many square feet?
900 square foot, 2-bedroom, 1 bath house. You cannot find one for under $1 million. Now, that's in a nice area, but it's a small house. Now, I will tell you, Palm Beach is the most expensive real estate in Florida.
Mhm.
And Mar-a-Lago is the most spectacular house in all of Palm Beach. So you're talking about the best house in the best neighborhood in all of Florida, which I would say Florida is a pretty highly valued state. I mean, I can't imagine that house being less than $500 million. I mean, just as a residence, and forget the country club part of it. So, I mean, these, I don't know, have you ever visited Mar-a-Lago?
No, but I mean, you can look around in that area. If you go to the houses within a block of it, they're worth more than what this judge valued Mar-a-Lago at. But Mar-a-Lago is a massive complex.
It's massive complex. And it's beautiful. It's historic. It is a gold. It is like a diamond in a crown. And I can't believe, this judge, like he says, 18 million. Here's the problem in Florida tax assessment, or not the problem, the benefit of living in Florida is that when you buy a house, there's a tax valuation. There is a limitation on how much they can raise your taxes every year when it's your primary homestead. So they can only raise it a small percentage every year. So if you bought a house 10, 15, 20 years ago for 18 million, it gradually goes up. Meanwhile, the economy is exploding, the real estate's going nuts, and it's valued. But your tax assessment by law and constitution must stay low. So for him to say tax valuation equals value of the house is ridiculous. It's market value, and that thing must be worth $500 million.
Well, and Squinty Cat brings up a point. Rush Limbaugh's home was just down the road from Trump, and it sold for $155 million, and they bulldozed it. And guys,
that was land value.
If you're not familiar, that's a very common thing, especially if you go to Delaware and Maryland along the coast or the Chesapeake Bay. I mean, you can see it down south too, but it's not as common. But especially like up in the north, like especially like Delaware and even in Florida, like in because I saw this all the time in Florida. People have a house they built like in the 60s or 70s, and then the house sells and immediately whoever bought it bulldozed it, and then they build up vertically and make the most of the space. So it's not uncommon at all to do that.
And just to get an idea of what Mar-a-Lago, it's a huge house. It's a historic house, and it covers all the way. It's the barrier. It's on the barrier island. It's right in the corner. It's a corner lot on the Golden Bridge, and it goes from the river to the ocean. So the property spans the entire length of the across the whole way. It's like huge. Yeah, here, check it out. Now, see these little houses right next to it? Those are like $150 million houses.
So here's guys, this
right, it's
like
insane.
Here's what we're talking about, and we'll just cancel this out because we don't need the dot anymore. So here is
river to the sea, right?
This is how big it's on one of the barrier islands on West Palm Beach.
Well, Palm Beach is different from West Palm. You got to be careful from West Palm. Yeah, see, so if you drive down the beach there, that's South Ocean
right
Boulevard.
Here
exactly. Yeah,
is all of Mar-a-Lago. And look, if you look at and compare it to the next set of things,
and I think he actually owns the property on the beach there too, so it crosses the ocean, the Ocean Boulevard there.
Look at all these houses, like 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29. I know I probably undercounted, but think about it. 25 to 30 houses are in the same comparable size piece of land that Mar-a-Lago occupies.
Yep, and those are $100 million.
Yeah. These houses, minimum probably $25, $30 million, and that's for the poor people house.
Yeah, there just is no house similar to Mar-a-Lago. I mean, you look up there, and these Palm Beach houses are the most exclusive real estate in all the country, really.
Right now, this is the hopping place.
I mean,
let's go on. Well, here we'll cheat.
The rich people don't want to see it from the road. So, but you can take a look. You can see. I mean, so Rush Limbaugh owned like one of those houses, and that sold for $155 for lot value.
Yeah.
There's just they're not making any more land there.
161 Via Palma. We'll cheat here and do
So for this guy to say that the Mar-a-Lago is worth $18 million is delusional.
Yeah.
I mean, it is so radically, it's at least 1, maybe 2 orders of magnitude too low.
Here we go, chat. Here we're gonna do this here. We're gonna do we'll do Zillow. Okay. So here's Mar-a-Lago. This isn't even, I don't understand why this is better quality pictures than Google does, but it does. They have a better quality satellite here. And it's funny because they're using Google. Anyway, so this is Mar-a-Lago, chat. The house right behind it, $27 million. The house right on the end of the street, $55 million. This one's for the Po folk. It's where the maid lives. $10.7 million, $9.3 million, $13 million, $20 million, $22 million. I mean, just look at all these. Look at all these houses. These are all beautiful houses. Okay, well, there's a sandcastle. $45 million.
Yeah, that one right there. That's for sale.
Yeah.
Hey, let's go in. You and me, we can split it.
Yeah. $36 million, Chad. I mean, check these places out. This one here, this looks insane. Whatever this one is.
That's part of Mar-a-Lago.
Oh, that's part of Mar-a-Lago? Okay.
Yeah.
Well, there you go. Even better.
He goes from that's on the ocean. That's the Mar-a-Lago side. I got to
Is this Mar-a-Lago here too?
I think so. I think all of this is.
Okay. Yeah. Okay. Well, there you go. That's nice. It's a nice little compound. But yeah, like $31 million. Like, guys, this stuff is no joke.
See, and one of the nice things, all of this whole strip here is all of this.
There's a house down the road, $50 million, and it's inland. It's not even on the water. I mean, check, like, these are insane.
But note that there's nothing like Mar-a-Lago.
$278 million. Yeah, the guy's $65 million, $40 million. One of these spaces, this house right here, is $126 million, and that's because of the land. Look at all that land it's sitting on. Because look up here to the north, all these houses are sitting on each other.
Yeah,
all those houses sit on each other, eat up all the property space. So if that one's worth $126 million, look how many of those would fit in here.
Yeah, it's not even, it's insane.
Yeah. So
I mean, you just pointed out a house like this house right here, which is tiny compared to Mar-a-Lago, is 45 million. So that's 3 times the price of Mar-a-Lago. Give me a break.
Yeah. Nobody in the right mind would agree with that. I mean, even this little strip of land, $1.74 million. You know, basically they're arguing this house right here, a 4,000 square foot house, is basically the value of Mar-a-Lago. It's like, no, that would not, no, nobody would ever do that. So
anyways, well, that was
ridiculousness,
fun.
ridiculousness.
Yes,
but yes,
yeah,
that's
ridiculous.
That's what the judge did, chat. So here we go.
Sir, are you asking us to draw?
Also, his time was up, but because the judges have questions, they're allowed to ask them. And that's because they make the rules.
Any bright line rules as to the contour of the AG's authority under 6312, or are you asking us to scrutinize the evidence that was adduced either at summary judgment with respect to claim number 1 and then at trial with respect to 2 through 7?
The latter, Your Honor. So our argument is on the unique facts of this case. You cannot come to the conclusion that the plain language of the statute was violated. And we argue, obviously, that they raises constitutional questions as well under Grasso and under the excessive fines clause and so forth. We make all those interpretive arguments. But the fundamental point is, if you look at these unique facts on this case, the statute just doesn't cover it. And if it does, it has no limitation.
It's your position that under the facts of this case, 6312 didn't support the taking the action that was taken.
That's exactly right, Your Honor. Thank you, Your Honor.
Good afternoon, Your Honors. Brian Isaac, as you know, I represent the non-party appellant attorneys. My argument is not as sexy as the other arguments, but I think it's a hugely important argument to me as an appellate litigator. I think that the New York State judicial system is the best in the world. I don't think it's better arithmetically. I think it's better geometrically. And I think most of the credit goes to you, but some of it goes to us also. You can't do your job in an exemplary fashion unless we do our job competently. And every single lawyer who practices in New York knows it's not what you get at the trial level, it's what you keep in the appellate division. It is an absolutely horrible idea, in my judgment, to sanction attorneys making motions for summary judgment in cases where they have to do it to preserve the issue, not only here, Your Honors.
You don't want to take a chance on the appellate court saying, oh, they didn't preserve the issue.
Judge, it's not only here. This is a Trump case. Like him, don't like him.
Now, yes, he's bringing up a point, guys. These attorneys were being sanctioned, and we were going to cover this. The attorneys were being, Engoron tried to sanction them for filing their summary judgment motions. But as this attorney's pointing out, you have to preserve the record. You have to preserve your record. You have to preserve things for appeal. And that's not frivolous. You're doing your job, and the judge is bringing it up here.
Doesn't matter. This case is a case that definitionally could go to the Court of Appeals. Look at 522B41. Look at Cialina against Erie Preserve. Look at the number of amicus briefs that you had. I couldn't even read them. You have to preserve these issues. And there's one fact that I want to bring to your attention. I know you know it, but we probably should have brought it out in the brief more. You have interest of justice jurisdiction. You can, if you want, decide unpreserved issues. You almost never do it. If you don't believe me, just run my name. Just put Brian J. Isaac, in quotes, within 8, put preserved, unpreserved, not preserved. See how good I've been. I'm not 0 for 5. I'm not 0 for 10. I'm 0 for 3 decades on that. But this court can do it. The Court of Appeals can't.
Now, that's funny, because he's saying you guys could do it, but you never do it. And it's correct. They never will take up an issue that's not preserved. They never do it. And he's saying, I'm not 0 for whatever. He's like, I'm 0 for 1,000. And the Court of Appeals is the Supreme Court. And he's saying they'll never touch it. Oh, sorry, Steve, are you saying something? Steve?
Oh, no, I'm just listening away. This guy's a bit of a, can you hear me?
Yeah, I can hear you. I can hear you.
I'm just saying, I'm just listening.
Yeah, he's very good. I like his style.
For 10, I'm 0 for 3 decades on that.
I don't know.
But this court can do it. The Court of Appeals can't. They do not have any interest of justice jurisdiction. They are not allowed to decide mixed questions of law and fact. They can't decide damage issues. They can't decide that a case is against the credible weight of the evidence. How can a competent attorney, and these people are competent attorneys risk a $440 million malpractice claim by not raising an argument that's a tenable argument. And I'm not going to go over my time because I don't, but I wanted to say something to you. The Attorney General and the trial judge excoriated the lawyers for making a motion for summary judgment on disgorgement at the summary judgment level. One of the cases they rely on is People against Ernst & Young, which you know. Can I read to you what you said? This isn't Brian Isaac. It's not Michael Ross who wrote the brief for me. This is the Appellate Division, First Department. I'm reading it verbatim. Quote, therefore, while the Attorney General does not allege direct injury to the public or consumers as a result of defendants' alleged collusion with Lehman Brothers in committing fraud, the equitable remedy of disgorgement is available in this action. Here's the key point. And it was premature to categorically preclude it at the pleading stage. That's verbatim. That is exactly what these lawyers did. And to be sanctioned for it is just wrong and threatens the integrity of what I think is the greatest juridical system we've seen. You shouldn't allow it.
Good for
Okay,
him.
guys.
I like that argument.
It's very quick. Okay, guys. Trump's attorneys got sanctioned. Like, they filed motions and Judge Engoron said, you guys are pieces of shit. I'm punishing you for that. Trump's attorneys had to get their own attorneys because when you get sanctioned, you have to defend yourself. It's not Trump's attorney. These are the guys, these are for Trump's attorneys hired their own attorney and had to appeal an issue. The thing is, because they're different parties, they can't use the same guy. They have to make their own separate arguments. So it's not that. Like I said, it's for the sanction. He is the attorney for the sanctioned defense attorneys. When these were Trump's defense attorneys, they got in trouble by Judge Engoron, so they had to defend themselves.
Yeah, well, this is the tyranny that's creeping in our country, which is now we're gonna sanction lawyers for making arguments in court, and we don't like you coming up here, so we're gonna.
Yes.
And it's becoming much more personal, much more partisan.
Yes.
And you got a judge and attorney general who are colluding. If the appellate court agrees with it, it's game over.
Yeah.
And they're actively, there's a group of Democrats who are actively targeting every lawyer who represents Trump.
Oh yeah, or
Across the
even does
country,
anything
looking
for
to
him.
get their bar license, looking to harass them with ethical things, looking to sanction them. And and he's just the latest guy. If they win against him, they will win against everybody who's in their way, and it's a power play.
Yeah, and Cripple, think about it like this, DK. When Brian Steele got sanctioned by Judge Glanville, he had an attorney come in and help him. So, I mean, there most of the time, and Steve, you would do this too. If you ever got held in contempt of court and you had a show cause hearing, okay, you're working in a law firm, you might have one of your firm's attorneys come in. Hey, man, I need you to help me here. I need somebody to represent me and watch my ass.
Yeah, we actually the only time I ever got close to getting held in contempt was I was brought into a very difficult trial to discipline. I'm sorry, you got to.
Oh, no. I was going to say you would use that guy and you'd say, hey, man, come help me. Or in the public defender's office, somebody would come in and help you. You always try to have somebody help you because you don't want to deal with this by yourself because you're invested in it. Kind of like how Judge Glanville got all angry and fired up. Judge Engoron got all angry and fired up. Well, that's not a big deal for the judge because you fuck up, nothing happens to you. When you're defending yourself against a judge who's already pissed off at you, you have to do it the right way. You need somebody there who's not invested. You need somebody who's being impartial, who might have to say, hey, man, you really did mess up. You need to eat crow. Or he might say, no, man, you're good to go. Fight this. But you need that independent party there. So these judges were held by Judge Engoron to have violated court rules and ethics, and he sanctioned them. And they're now appealing that, and they need their own attorney. So, and the other thing is the trial attorneys never do appeals because part of your argument might be, well, the trial attorney screwed up. So that's also part of the issue there too.
Yeah, no, I was going to say that like when I've never been held in contempt but there was one time I was close, mainly because I was brought in as a bad guy to discipline the judge and the prosecutors. And they were really after me. And the public defender's office, we had a team of public defenders who were on standby
Mhm.
that in case I got held in contempt, they were going to immediately find to the Court of Appeals to get me released from jail. But you got to sometimes do that in the face of it. But this is just outrageous that they're holding these attorneys in contempt.
And what happened here is that he asked for 3 minutes. He's got 5 minutes to make it because he's not the main party. So he gets a 5-minute argument. He did it 3 minutes and he's saving 2 for rebuttal. And now the prosecutor gets to go. So here we go.
Thank you. Counsel. So you have 10 minutes on this first. You have 10 minutes on this.
Well, I don't know if it's easier, Your Honor. Since we're the appellees, I'm happy to just take the full 15 minutes as the appellee, and that I
Okay.
think that maybe simplifies things. May it please the court, Judith Vale for the New York Attorney General's office. All of the defendants repeatedly
Ms.
violated.
Vale, can you identify any previous case in which the Attorney General sued under Executive Law 6312 to upset a private business transaction that was between equally sophisticated partners, where the supposed victim had the ability and legal obligation to discover the allegedly misrepresented matters by conducting its own due diligence, where the supposed wrongdoer advised the supposed victim through written disclaimers to conduct its own due diligence and to draw its own conclusions, where the alleged misrepresentation almost entirely concerned inherently subjective valuations of properties and businesses.
Yes.
This is a
There's
when
a
you
pro
start
Trump
out.
judge.
Yes, this judge is saying, have you ever done this before? Because he's asking the question because he's like, I don't think you have, and I think this is bullshit. So yes, they're getting felted, guys.
Yeah,
But here,
that was not a question. That was a speech. That was a
Yes,
speech, not a question.
That was a statement. That was a statement. But anyways, we're going to back it up real quick here. We'll see what she answers.
Inherently subjective valuations of properties and businesses.
Yes.
And where the victim never complained about any fraud in the transactional losses from it. Because I've gone through the cases which you've cited, and all of them always involved the consumer protection aspect. It involved protection of the market.
Oh, several responses.
And I want to add to his question, and little to no impact on the public marketplace.
Well, maybe I'll take that first, Your Honor.
Oh, it wasn't just him punching at her. She comes in and says, on top of it, comes up on top of it, chat. That's not a good way to start. This is how normally things go when I've made oral arguments before and I'm doing a criminal case, and it's like, you're boned. You're boned. So here we go. Oh, boy.
And work backwards. There was absolutely a public impact and a public interest here. There are at least 4 different public harms from the kind of misconduct here. First of all, when deceptively hidden risks are injected into the market, that does hurt the counterparties, and there was harm to the counterparties here, but it also harms other market participants and the market as a whole because they are not understanding the risks, they are not pricing them in properly, and they are not prepared for what might happen if the true risks come to pass. Also, as the legislature made clear in passing 6312, it was concerned with harms to the honest business people who don't do the misconduct and therefore don't get the kind of benefit that they got here.
I suppose you're referring to the fact that Trump received a lower interest rate than he might otherwise have received. But haven't you yourself conceded that the assets were sufficient to get the lower interest rate of the private wealth management direction?
Absolutely not, Your Honor. That is not conceded one bit, and the evidence is to the contrary. If you look at what the Deutsche Bank witnesses testified to, Haig said that the financial strength of the guarantor affects the pricing in terms of the loan. That's in the record at 28167 to 68, and it affects whether the private wealth management group would be allowed to do this deal at all. That's at 28150 of the record. And you have to remember something. As the net worth as the statements were coming in, the Deutsche Bank was doing a stress test. So if without the fraud, the net worth and liquidity would have started much lower. And then you do the stress test and it takes it down much lower. It does not look like such a strong financial guarantee anymore. It does not look like an ironclad guarantee anymore. And it was absolutely a fair inference that Deutsche Bank would not have given these loans without the financial strength being inflated. That was also evident from Haig and McCarty testifying about the incredible
Doesn't Mr.
collateral.
Doesn't Mr. Hay testify that there were 14 factors and this was the least important factor?
Well, certainly there are multiple factors that go into the risk assessment, but both for materiality and for disgorgement, the issue is not whether there's only one factor. There's often a lot of factors that are being considered. For materiality, it's whether it's important to the overall total mix of information. And this was absolutely critical to the overall mix of information, not only because they were looking specifically at what the net worth was in order to decide the terms of the loan, in order to figure out whether they would take on this risk, but also the financial statements were coming in each year and they were important, critical to the loans each year because Deutsche Bank was reassessing the risk every single year. And it was using—
I'm sorry, but what's being described sounds an awful lot like a potential commercial dispute between private actors.
Well, to go back to the first question about whether there's other examples of this, there are other examples of this. In the First American case, the Attorney General brought a 6312 case where the transaction at issue was between a very big bank, Wells Fargo, and a professional appraisal firm.
But
And-
wasn't the concern there that the public would ultimately be negatively impacted and affected by what those corporate actors were doing?
And that concern is here as well, because when you have hidden risks getting injected into the market, that hurts the market and honest participants in the—
This is not going well for her. She is getting peppered, chat. Notice the type of questions and the tempo of these questions. They are just not letting up. Oh, we need to keep playing.
The market. And the legislature also decided, contrary to what defendants think, that making sure that business in New York stays honest is the way to attract and keep business
So to that
in New
point,
York.
the Executive Law 6312, I just want to read a section of it. Well, not exactly, but was enacted to promote and protect honesty and integrity. It's the same question I asked the other side. In commercial marketplaces in New York, by stopping fraudulent and illegal businesses. To accomplish this purpose, the statute authorizes the Attorney General to bring civil enforcement proceedings on behalf of the people whenever any person shall engage in repeated fraudulent or illegal acts or otherwise demonstrate persistent fraud or illegality in the carrying on, conducting, or transacting of business. I don't read harm or threat of harm in that, but the other side is saying that that is to be read into the statute. Are there any cases where the language harm or threat to harm limits the scope of the Attorney General?
No, Your Honor, not as to liability and not in cases like this where what the Attorney General is seeking is injunctive relief and disgorgement. Greenberg from the New York Court of Appeals and Ernst & Young from this court make clear that reliance by a counterparty and actual harm to a counterparty are not required for liability for any of the claims here. And remember to think about the illegality claims as well, because it's not just fraud.
That's
Could you just
very
let her finish the question? Just
So for the
answer,
illegality
please.
claims, you look to the underlying penal law provisions. And for something like issuing false financial statements, there's no requirement for reliance. There's intent and there's materiality, which was proved at trial. But if someone issues a false financial statement to their counterparty, the counterparty gets it and is not fooled, picks up the phone and calls the enforcement authorities, the crime has still been committed, even though the counterparty didn't rely on it at all.
So you're pointing to Ernst & Young, you're pointing to First American. Ernst & Young, you're dealing with the collapse of Lehman Brothers. First American, you're dealing with an action brought against an appraiser who overvalued properties at the behest of a lender perpetrating a scheme to induce unsophisticated consumers into taking out home loans that they could not afford. It hardly seems that justifies bringing an action to protect Deutsche Bank against President Trump, which is what you have here. I mean, you've got two really sophisticated parties in which no one lost any money. And that was the point of my initial question. Every case that you cite involved where there was damage to consumers, damage to the marketplace. You've got a scheme to get unsophisticated consumers to take out home loans. You got a collapse of Lehman Brothers. You don't have anything like that here.
Well, first of all, Your Honor, the statute doesn't require that whatsoever for liability. And the statute is written broadly because the legislature wants the Attorney General to go in and stop fraud and illegality.
Also,
whether
an
it-
example of what you're talking about, I think, is People versus Allen, isn't it? There it was just a dispute among partners.
Yes, and the
it didn't affect the
investors-
public, I mean,
Sorry, go ahead.
at all. But I think you hear underneath all these questions, the question of mission creep. Has 6312 morphed into something that it was not meant to do? And that's something you must address, because there has to be some limitation on what the Attorney General can do in interfering in these private transactions, as Justice Friedman said, that where people don't claim harm. So what is the limiting principle?
Well, I'll say two things, Your Honor. Well, first of all, the limiting principle are what's in the law. So the illegality claims require intent. They require materiality.
Let's talk about the standalone.
Just for the 6312 fraud. Well, this court has defined that rather
Pretty
broadly,
much,
but there are
Maddie.
still limits. It is not falsity in the wind. First of all, it is not falsity that you whisper to someone on the couch. It has to be related and relevant to the business at hand.
And she's in a horrible position. She has to argue that this whole situation where nobody got harmed, no one really was harmed. She has to make all these ethereal arguments about all the other honest investors who, you know, everybody else, because they're all suckers and weren't able to figure out how Trump did it, it's unfair to them. That's the argument she has to make here, because there is no good argument. She's really hurting. That's the one thing. I mean, that's the thing. She's not a DEI hire. She has a very shitty position to make. And that's the problem. She's arguing from a very weak position the judges aren't receptive to.
Well, it's you know, it's tough because this is such a political case. I mean,
and
to
these
me,
facts aren't good.
But what I'm seeing, to me, it's bad faith on the part of the state.
Yes,
which is what you're getting a lot now, because the state institutions of power have been weaponized against the people. And you know, when you have a statute that's so overbroad and you have unchecked power in prosecutors' offices, and then, you know, and each institution falls one by one to DEI and to leftist takeover, soon there will be no check on state power. And this is called tyranny and mission creep.
Yes.
What the guy was saying, he's like, what reasonable limitation? If you've got an overbroad statute and you can go after anybody you want, making up fraudulent paper, then there is no limitation. You could take down any rich person you want. Then that's what they're trying to achieve.
Sure.
The state, if the state was acting in good faith, they would concede some of these points, but they're not, because they're trying to get it.
Well, and that's the thing, though. Like, she is kind of following orders here. But, I mean, she's not the one who prosecuted this. This is her. This is what happens when you have a bad case in her situation. The facts don't support her. The facts don't help her. The whole case smells to high heaven. The principles they're demanding and the rulings they want are just against the way we would want things to go. And the judges are saying that. They're like, this makes no damn sense. Why should we do this? And she doesn't really have good answers for it. So it's not that she's a DEI hire. I'm sure she's a very skilled attorney, Ag. It's just when you don't have good facts and the judges are hammering you, you look like a blithering idiot because you don't have anything good to argue. And Steve, I'm sure you've been there before where you have bad facts or bad issues and all you do is you got to take your punches.
Yeah, I don't know. That's a good question. I wouldn't say that. I wouldn't say that necessarily. You know, we have something called the Anders brief. So that if we have when I was doing a public defender appeals, if I didn't believe in the case, I would file an Anders brief, which is about half the time.
Well, no, you could. Well, I'm not saying that. I'm saying if you had a case where you believed in it, but you still had really bad facts and the law wasn't in your favor.
Well, you find that you try to craft either the law or the facts to suit the argument that you've made. But I'm thankful for the Anders brief because I would only have to bring cases that I felt strongly with.
Yes.
And of course, in the death penalty context, I don't believe in the death penalty. I think I've got a whole book on all the problems with Florida's death penalty, independent of any facts related to any specific case. At Steve Cosby. Anyways, so I don't know. I mean, it's a tough position, but the only check here, I just want people to realize the only check here between absolute tyranny and you is these 5 black
Yes.
robes sitting in front of her.
Yes. There's 5 of them, and this is the firewall. This is the firewall. Because certainly
so
this woman doesn't think, I mean, if, the Attorney General's office doesn't think they've done wrong. Judge Engoron doesn't think they've done wrong. So, yeah, they are arguing some of the most insane arguments, but the state will do this when they're in a bad case. They will make outlandish arguments. I think there was
But see,
one.
they don't have to do that. See,
Well,
this
they
is
do,
the problem. But here's the thing: the state is the one bringing the charges. The state is the one that controls it. If you, as a prosecutor, feel that you are not making, you have a bad case or there's bad facts, drop the charge or lower the charge, change the charge. Don't push eccentric novel theories to get the enemy because you don't like the person.
I agree
that
with
is
that.
contrary. And but that's what we're doing. These Soros type prosecutors are weaponizing the law and the state attorney's offices against us.
Yeah. And the one thing I said this before, I think you'd probably agree. When you're a prosecutor, if you are finding yourself in uncharted territory, like, oh, nobody's ever charged us before, that's a bad sign.
Right. Oh, absolutely.
You are not, this is not in a lab for you to conduct experiments and be novel and creative. That's for the defense attorney to do. Or go to civil court and make novel theory. Don't make novel theory in a criminal case.
Yeah, I just had a case where I'm familiar with, let's say I go about that far, which there was an 18-year-old at high school girl got in fight with a 17-year-old girl at school, and no prior record on the part of the 18-year-old. And they charged it as felony child abuse. And technically, it could be done. It's prosecutor's decision, but it's a simple battery.
Yeah,
it's not a felony child abuse, but it's a novel legal theory. We're going to push it because I don't know for whatever bizarro reason. Sometimes it's just power extortion moves.
And the funny thing is, if you had asked the state legislature when they passed that law, is this what you intended for child abuse to be? They all would have said, no, there's no way in hell I'd want that. So they would keep doing it anyway. So let's keep going here.
And it does have to have a capacity or tendency to deceive. It has to have a capacity or tendency to deceive. And I will stress, Your Honor, that this does have harm to the public and to the markets. And I think what Your Honor is saying is that in some of the other cases, the ripple effects happen to happen. It went so far that the ripple effects from fraud went on to hurt the market. But what the legislature wanted was 6312, just like for the Martin Act. And the Court of Appeals talks about this in assured guarantee.
To be prophylactic, is that what you're about to say, counsel?
Yes. Look at the assured guarantee case from the Court of Appeals. It talks about how a big point of these statutes, not the only point, but a big point is for the Attorney General to go in quickly to stop the fraud and illegality before it gets to the point that counterparties are harmed or it has those kinds of ripple effects in the market. I do want to, though, push back on the idea that Deutsche Bank never complained and wasn't harmed at all. Deutsche Bank did complain. When they first found out about the alleged misstatements and omissions, they raised serious concerns with defendants, said that misstatements in the financial statements would be an event of default. They asked for more information, and when they didn't get more information, they exited the entire relationship with the Trumps. That shows that they cared about the financial statements being truthful and accurate.
What year was that in? What year was that in?
It was right when they first heard about the allegations. So I believe it was 2020. Your Honor, although I'd have to check the precise year on that. And Mazars as well, when Mazars found out about the alleged misstatements and omissions, they also sent a letter saying these financial statements should not be relied upon anymore. So it is not true that the counterparties didn't care or never complained, even though that's not required for 6312.
Also, I'm sorry.
Go ahead.
I'm moving off topic, so if you have a question on this, go ahead.
Maybe a better topic than mine. Back to Justice Moulton's point about line drawing, because I do think that is very important in this case. You know the history of this statute. It's passed under then AG Javits, and then was really amplified by AG Lefkowitz over the years. And when I went back and read the bill jackets, the common thread was always we need greater power. The AG needs greater powers as the people's lawyer to protect consumers, civil rights, and the environment. And so again, with that sort of historical backdrop to this law, how do we draw a line or at least put up some guardrails to know when the AG is operating well within her admittedly broad sphere of 6312, and when she is going into an area that wasn't intended for her jurisdiction?
Sure, Your Honor. Well, I will say, although there was certainly concern about consumers, especially at the outset of 6312, in some of the legislative history, there were multiple bills being passed, and some of them were more specifically consumer protection statutes, which I think explains some of the focus. And the legislature wrote this statute. It doesn't say consumers in it. It wasn't focused. I mean, of course, we want to protect consumers. I'm not.
And
not
it
saying
does
otherwise,
start off. It does start off with the words to protect honesty and integrity in the commercial marketplace. So,
yes, Your Honor, and it also is it says quite broadly, whenever any person engages in fraud or illegality, whether that is meant to include businesses large or small, because this kind of deceptive risk does cause problems for the honest business people who don't do it this way and don't get the ill-gotten gains. And it does inject risks into the market. I mean, Your Honor, there was probably a time when most of us didn't know what a repo 105 was, which is what brought down Lehman, or what a RMBS was. And maybe, in an ideal world, the Attorney General or somebody else would have gone in and stopped that fraud and illegality when it was still just among the.
Now notice she's trying to weave in Lehman Brothers and the collapse and Wall Street greed she's trying to do this to kind of tinge things a little bit and kind of help try to get them to say, oh yeah, this is just like fighting Lehman Brothers by stopping Trump.
Sophisticated counterparties, and before it had the enormous harms and ripple effects that it ended up having.
So let me just ask you, you mentioned about the ripple effect, going on. If the threat of harm or whatever the ripple effect is so remote, does the conduct fall still? I mean, how remote does it have to be? It's the same question with regard to this line drawing, in order for the AG to follow through.
I mean, I think the remoteness problem
until
is,
it's outside of the scope of the statute as intended.
I mean, I think at least for 6312 fraud standing alone, I think the limit does come in through the capacity or tendency to deceive requirement. I don't think that the legislature wanted to have this kind of like evaluation about the precise harm out of a specific transaction. I mean, that's why harm is an issue that might be for restitution, but that's not an issue here. But there is a limit, and it comes from the tendency or capacity to deceive standard that this court has put on that does incorporate a materiality-like standard. I think when we say materiality is not required, we're talking about the reasonable investor, that materiality is not required. It's just which objective person you're looking to. There's still an objective standard. So there are.
That's a good point. And so which objective person are we looking to here, given that it is the nature of the transaction that it is? I don't want to belabor the background.
I mean, this court has said that the standard for 6312 fraud standing alone is the objectively reasonable, ordinary, and even unthinking person. But in this case, the court could use the higher standard and it would be fine. Because
I notice you say the ordinary standard on page 55 of your brief. You say these deceptive strategies had a capacity or tendency to deceive because they would have been relevant to and likely to mislead an ordinary person involved in the business dealings, and you cite to General Electric. Mm-hmm. Isn't the test here whether they were likely to mislead Deutsche Bank or Ladder Capital or the City of New York awarding a golf license, or Zurich on a surety bond program, or Everest National Insurance Company on a directors and officers policies? The defendant's statements were not meant for ordinary people. They were directed at some of the most sophisticated individuals and entities in business.
Well, if the court wants to use the standard of an objectively reasonable counterparty, sophisticated counterparty, fine. They had a capacity or tendency to deceive that sophisticated.
That seemed a little snitty the way she did that. I don't know if that was the best way to answer that question, but you do you, babe. You do you.
Party as well, because these misstatements and omissions were about objective facts.
Oops, yeah, what objective facts? Well, since Sean just disappeared, the objective fact that Mar-a-Lago is worth $18 million, that is the most absurd, unreal fact I've ever seen.
Sorry,
Just,
Chad.
you got bounced.
Yeah.
Yeah, I mean,
Sorry,
what objective? This is the more I'm hearing of this argument, the less. I mean, I thought, I'm obviously a partisan here too,
Yeah.
but I also am an appellate lawyer, and I'm a criminal appellate lawyer, and I've seen arguments enough to know that when somebody's losing, and so, but I hope that the court is going to give it to us, because, I'm very frightened that 5 robes appointed by D's will just say, "Oh, we'll get our guy."
Yes, guys, and we'll back up just for a second in case we lost some of that here. So here we go. And the court's bringing up, like, these guys, this is the most sophisticated people in the world. These aren't just, this isn't Boiler Room where they're pumping it out to random, guys in Iowa.
Deceive that sophisticated party as well, because these misstatements and omissions were about objective facts that were extremely important and that any reasonable counterparty would want to know. Any sophisticated, reasonable counterparty would want to know that the defendants were valuing an apartment based on 20,000 square feet more than it really was, based on pretending that rent regulations on certain apartments didn't exist, based on pretending that the Mar-a-Lago restrictions didn't exist. Your Honor asked about that. The trial court was very clear that it was not coming up with a magical valuation for itself. The problem with the Mar-a-Lago valuation is similar to what happened with the rent-regulated apartments. The restrictions in the deed are there. They are an objective fact. They are very restrictive. And even defendant's own expert at summary judgment, this is at 16502 of the record, agreed that the restrictions would decrease the value of Mar-a-Lago, but defendants valued it as if those restrictions didn't exist at all.
Counsel, I want to ask my question because your red light is on.
Absolutely, Your Honor.
Madam PJ,
on,
is
yes.
that
Yes.
Yeah, Trump, see, this is what you call stupid bureaucratic partisan thinking, blinded by ideology, because this was very well explained. So let's say the Trump is part of the Trump Mar-a-Lago complex is part of a private and exclusive club. And so therefore you're restricted by all these club rules. But the problem is that, they say, well, this restricts the value, this diminishes the value of his private residence or use because you have all these members. The problem is you have, Trump could just say, okay, I have one member and it's me. Now it just disappears by operation of the fact of operation. So, for them to say that these are major limitations on the valuation is just false. And it's like, well, because see, these no imagination bureaucrats or partisan blinded by people, they say, oh, well, that means you've got 100 club members who are going to be voting. No, that could be changed unilaterally. So
yes.
Yeah, and so the fact, just again, it's stupid to say that Mar-a-Lago is worth 18 million. That is, it's dishonest in the extreme. In fact, they're accusing Trump of overvaluing it.
Yes. Oh yeah.
The court is engaged in exactly the opposite in order to put somebody and to find somebody. They're doing a lot worse than what Trump ever did.
Yeah, and Engoron thought I showed him, I guarantee you.
Oh,
I showed him doing it.
Yeah, anyway, sorry.
No,
ranting.
you're fine. I thought it was very good. I thought it was a very good explanation there.
Yeah, I was ranting.
Needs to be said.
Yeah, Brad says, buy Bushwood.
Yeah.
That's right. This place sucks.
For the disgorgement calculations, wouldn't it have been more appropriate to calculate them by calculating the difference in valuation of the property versus the valuation provided to the banks to get the loans?
No, Your Honor, the disbursement calculation, what we needed was the reasonable approximation. What is the reasonable approximation of what defendant's fraud gained them? And defendant's theory is that the guarantee and the financial statements each year were worth nothing. But the point of the guarantee and the financial statements each year was to get the extremely favorable interest rates. And we were not speculating about the difference in interest rates. We had the counteroffer that Deutsche Bank, their own lenders, provided them for a loan without the guarantee and the financial statements. If I could touch very briefly on the statute of limitations, Your Honor.
Did you have another question?
I have a question that's
And I'll
similar
give
to
you
Judge
time for a
Rosado's,
second.
actually, which is the immense penalty in this case is troubling. So how do you tether the amount that was assessed by the Supreme Court to the harm that was caused here, where the parties left these transactions happy about how things went down?
Well, disgorgement, Your Honor, looks at taking the gain away from the wrongdoer. And although this is a large number, it's a large number for a couple reasons. One, because there was a lot of fraud. This went on, and illegality. It went on for 7 years during the statute of limitations period. Another reason is because the guarantee and the financial statements each year worked to get enormously favorable interest rate savings to the defendants. It was a difference of approximately 4 to 8 percentage points, obviously varied by year. That is an enormous benefit that they got from the misconduct. And it is not an excuse to say, well, our fraud was really successful, so we should get some of the money.
Was there double counting in the damages assessed for the old post office and the Ferry Point?
No, there was
deals?
not. There was not double counting, Your Honor. Two points on this. First of all, the interest rate savings and the sale profits are separate pots of money. The defendants got the interest rate savings off the top. There's no suggestion that they invested that savings into the OPO. They were using the loan, and so they got the interest rate off the top. That was the savings that they got each year. I mean, each year within the statute of limitations, they were getting a savings by doing the fraud over and over again and the illegality. And then the sale profits are separate. And the sale profits, it's not the proceeds. The proceeds of the loan of the sale were around $370 million. The trial court took out the repayment of the Deutsche Bank loan, and I think defendants themselves had taken out already the taxes. And Mr. Trump testified that the number for him, around 126 million in profits, was his profit. That was his profit or more. I mean, I'd happy to talk about the statute of limitations quickly, although I see that my red light is on. So,
Well, I'll give you more time for,
sure, Your Honor. On the statute,
So they're just think, no, your time's up. You're done. Why is she getting more time like this? I mean, they're just letting her go and go and go and go and go. I don't see. I mean, I thought her time was up by now. Or am I wrong, Steve? I thought her time was done.
Well, they can it's discretion of the court.
I know, but they're just going to let her run and run and run. It's like, you only gave Trump 15 minutes. I think, sorry, you're done.
Well,
Like,
that was her ex. She knew that she's getting pounded, so she wants to sit down. But they're like, no, we'll give you more time. You know.
Yeah, and I get that. It's a little frustrating though when they do that.
I like it when they do that because I can talk about anything forever. So.
Oh yeah, no, I get it. But yes, they might just be fucking with her, and they're just gonna let her keep shooting herself in the foot. I don't know, but I think it's fair, you know. Although I think Trump's attorney is like, you know what, fuck it, I'm fine with this. You know, it's like when you're sitting there watching the other attorneys get yelled at for something, you're just like, I'm glad that's not me. So, here we go. Let's see what they keep asking her.
limitations.
how much? I'll give you 3 minutes.
Thank you, Your Honor. On the statute of limitations, each use of a misleading statement in business and each issuance of a false financial statement is a violation of the statute. And it is helpful to look at the illegality claims. Every time someone issues a false financial statement, that is a crime. And it is no excuse under the statute of limitations to say, oh, although I issued a false statement in 2017, I should somehow, for statute of limitations purposes, be free and clear because I also issued a different false financial statement in 2011.
Is there any tension between your position and our prior decision that said we have to look to the accrual as of the date the transactions were completed?
No, Your Honor. I think the best reading of that language is that the transactions completed. The transaction is referring to the conduct that the statute is referring to, which is the fraud or illegality. So each time you issue a false financial statement, for example, that is a transaction.
I don't think it's referring to the loan.
No, Your Honor. If the court had wanted to refer to the loan completing or the loan initiating, it would have said that. And Ivanka was much differently situated. The problem, for what this court said about Ivanka Trump was that she was not sufficiently involved within the statute of limitations for her with the certification, preparation, review, or use of the statements. That was why she was released from the case. Whereas the defendants that remain, each personally were involved in the preparation, issuance, and use of the statements in business. And it would really be a distortion of 6312 and this court's precedent in cases like Allen. I mean, a similar thing was happening in Allen, where the original relationship between the counterparties started before the statute of limitations, but then new fraudulent or illegal acts were happening within the statute of limitations. And what the trial court said there and what this court affirmed was the new conduct that happened within the statute of limitations is timely and actionable, but the things that happen outside of the statute of limitations are not. And I do want to emphasize that neither the trial court nor the attorney general sought liability based on the fraud or illegality that happened in 2011 or 2012. That is not true. After this court's decision, the attorney general was not pursuing its claims for the interest rate differential for 2011 or 2012 or 2013. We were pursuing that before, and because of this court's decision, we stopped, and the trial court appropriately separated.
And he did not separate him. They used that as evidence of wrongdoing to tinge what happened.
Separated it and said the claims that are based on fraud or illegality that happened before 2014 are out, and the ones that happened in the statute of limitations period are in.
Do you want to respond to?
Well, I can touch very briefly on the sanctions, Your Honor. I mean, I think for the sanctions, I'll say two things. And one is it was not just one frivolous argument. It was multiple frivolous arguments happening, including both at summary judgment, raising the argument that disgorgement is not allowed under 6312 as a categorical matter. That is foreclosed by controlling New York Court of Appeals precedent in Greenberg. And counsel misquoted Greenberg in making that argument to make it seem as if Greenberg had not said what it said. And it was that combined with raising purely legal arguments about standing capacity to sue, raising those arguments again for the third time after the trial court had warned them and said at the motion to dismiss stage, these arguments are frivolous, but I'm not going to sanction you now. I'm warning you. And I understand the need and the feeling to preserve the need to preserve arguments for appeal. As an appellate attorney, I understand that. But what counsel did here was not write a sentence or two and say, for the purposes of preservation, we are adding this to our brief. They wrote the whole argument again, relying on all the same cases and all the same legal arguments without explaining what, as a factual matter, was different. And that was unnecessary and frivolous.
Thank you.
Thank you.
Very bad.
Mr. Sauer?
Steve, what's that?
Very bad. I mean,
Yeah.
again, this is bad. I mean, I don't know. What you're going to, so the state, the power of government is going to be levied against the lawyers of citizens who are seeking to defend themselves.
I honestly would think at that point, they should have said, we have no, it's not.
We have no position
Yeah,
here.
they shouldn't have a position on it because Judge Engoron should have said, okay, fine, Judge Engoron could send counsel if he wants to, I guess. That would make more sense. But having the party, you weren't involved in it. It's not your position.
Right.
I don't think they have standing to argue what the judge
No,
did there.
exactly. Okay, and let's Sean, you just knocked it out of the park right there.
Yeah.
And that shows you that the state of New York and the prosecutors there and the AGs here are acting in bad faith because they were not a party to that argument. That basically the judge was sanctioning a lawyer on the Trump team. So it's between the judge and the lawyers on the Trump team. The AG's office, the attorney general or the prosecutors have no position, have nothing to say about that. It's not them to weigh in on which side they think is right or wrong.
Yeah.
But now they're coming in and saying, oh, but we take the judge's side below.
Yes.
Why do you take the judge's side? Why do you care? It doesn't matter.
Well, it's not even they care, but it's what authority do you have to do that? Because it's like if, like you said, when you were worried about getting held in contempt, the judge holds you in contempt. The prosecutor doesn't get to say dick at that point.
Right.
All they could say is if they wanted to say, Your Honor, we disagree. We think you're out of line here. That would probably be fine. They would have the right to say, Your Honor, that's not proper. But for them to go, hey, judge, that's a great idea. We support you. Who fucking asked you? Who put the nickel in you?
That's not their position. That's not. Let's just talk about it from a purely statutory position.
Yes,
a statutory or a constitutional position. They are not involved in that. They are the state. They are the executive. The executive is not involved in a dispute between a judicial branch, right? They have the party that they are against is the Trump in this case, or the client, not the lawyers, but not the judge. It's really a dangerous thing that they're doing there, and it's spreading. This is happening all the time. I've got multiple instances that are related and tangentially related that I've seen recently, and it's just lack of understanding. Maybe it's a lowering of IQ from lawyers across the board, but it's a major problem.
That's why I hope the attorney for the attorneys there, he comes up and says, it doesn't fucking matter what she wants. It's not her fucking argument to make. The court, this appeals court should look at the record and the arguments made by the attorneys, and that's it. The state has no right to be involved in that argument. So, yeah, it's a dictatorship, but I mean, I will say even these judges are saying, look, we hate Donald Trump, but even this is bullshit.
Yeah, but I'll tell you,
it says a lot when you're at that point.
Yeah, I mean, the thing, Trump's just in the way.
Yes.
Because it's like he's got lots of money. He's very powerful. I mean, and not to use present examples, but, they went after little old me too.
Yeah.
By lying and falsely characterizing stuff, and got me. So, I mean, it's just we're just on the list. Social credit system scores that they have in China, that's right around the corner. Institutions that are taken over and there's no check on them. It's very dangerous. We are playing with fire. I mean, we are close to the end of the republic in this kind of stuff. I mean, it's very critical that we get some handles and reestablish our founding principles and limitations on government, because what you're talking about here is absolute and utter financial ruin on the basis of absolutely nothing.
Yeah.
Minor inconsistencies where the parties agree, there's no dispute, there's no loss, but the state parachutes in on the behalf of the little guy everywhere to say, you lied on some paper 10 years ago, and so we're going to destroy you.
Yes. Yes. And now, Bush, you asked a question. Did the judge sanction these attorneys because they appealed to higher court? No. The argument by Judge Engoron was that they made repeated Engoron claims. They made arguments he told them to quit making that he'd already denied, and that is an issue. If you keep bringing up the same thing over and over and over and over and over again, a judge could tell you, shut the fuck up. If you don't, I'm going to hold you in contempt. But also the allegation is that these guys improperly cited cases, and basically Engoron's claiming they lied about how the cases were set up. Now, obviously, Trump and his attorneys don't think that happened.
Yeah, but there's also a good faith argument.
Yes.
You can't say this court has decided this case, and if you disagree with that case, then you're in contempt and you must be sanctioned. Think about that. That means that the law can never be changed once a judge speaks it out of this little pen.
Well, no, but I think the argument is that Engoron had said, I disagree. Well, no, that they brought up the issue, but it was that Engoron's claiming they lied about what the holding of a case was, that they misstated it intentionally. Now, obviously, I think Engoron's full of shit, but that's the argument he made, and that's the argument there. The Attorney General was just pointing out, like, well, look, they lied. They're bad guys. So that was what she was trying to argue there, was that they had done things that warranted it, which I doubt they did, but that's the argument that Engoron and which now the state is doing, which I said they shouldn't be allowed to do. So let's take a look and see what Trump's attorney says, and then the attorney for counsel says here.
Thank you, Your Honor. Just pivoting to that last point. Last year, the Attorney General's office was here on the continuing wrong doctrine, making the exact same arguments. This court rejected them and Trump won. And we're hearing the same arguments again, citing some of the same case law that was sanctionable for our attorneys in the lower court. But here we are. Now, I want to point the court to two citations in the summary judgment record that I think frame a lot of the questions that.
Now, that's a very good point. He's saying, like, look, the attorneys in the other Trump case that we were here for, you guys agreed, hey, you know what, we need to change the law. So that judge was wrong too. So they're trying to bring up that issue there, that's saying, look, you guys have already said this, judges might be wrong, so here we go.
My colleague was asked. At 13865, there's unrebutted testimony in the summary judgment record that at least creates a disputed material fact that President Trump would have got the same deal from
13865, chat. There were 13,000 pages in this trial, at least. That's a big transcript. Holy cow.
Deutsche Bank if his net worth had been as low as $1 billion. In their calculation, it was never below $3 billion. So it's triple the threshold. And the clear testimony is the interest rates would have been the same. He would have been they held up a chart that would have been on the same pricing chart. So this notion that there were these 8 basis points at issue is just not supportable. Secondly, at 20,042 to 44 of the record and in other places, the Deutsche Bank witness said, we independently assess all these valuations. We are not relying on the numbers that the client is giving us. We do our own independent assessment. That is our due diligence. That's the understanding of the relevant marketplace.
I'm sorry, sir, but
Nordbank.
So we're talking now about cause of action number one, the fraud under 6312.
Yes, and the causation argument as to disgorgement. Yes.
Okay.
Yeah.
So we know under, point taken, as to the liability on cause of action number one, we know fraud under 6312 has a much broader meaning than common law fraud. And so there it's, as your friend pointed out, the standard is the capacity or tendency to deceive. Did those statements have the capacity to deceive?
Absolutely not, Your Honor, for at least 3 reasons. First of all, they're gap compliant. They're not misrepresentations. All the key things they point to is this was wrong and this was wrong. The unrebutted testimony, certainly in the summary judgment record starting at 17,916, is this is what you do in a financial statement. You are allowed to do this. You are allowed to predict, for example, that you'll get your rent restrictions lifted or you'll get authority for, more units at Aberdeen. You're allowed to do that. You're allowed to make optimistic projections. You're allowed to disregard appraisals. What Professor Bartoff said is that appraisal could be sitting on your desk and you don't have to rely on it. And there's actually really powerful evidence in this case to show why that's true. Because if you look at 40 Wall Street, they said, in 2011 and 2012, the appraisals of 40 Wall Street were at 200 to 220 million, and you said 527 million. But they overlooked that a couple of years later. Cushman revised its appraisal and said it's worth 540 million, virtually matching what we had said, and they say is misleading. So it's kind of these astonishing issues. It's very similar to the valuation of Mar-a-Lago as $18 million based on a tax assessment. It's preposterous. It's a preposterous position that these factual things. So that's my first answer to that. But secondly, more importantly, we have sophisticated counterparties, as a lot of the questions pointed out. They're getting clear disclaimers. The disclaimers say what everybody already knows you do in this industry. You do your own due diligence. So how is there a capacity or tendency to deceive when you have these very clear disclaimers saying considerable judgment is required here?
That's a very good point. How am I committing fraud when I tell you, don't take my word for it, do your own homework? Don't rely on what I'm telling you. I don't see how that you can argue that's fraud.
Yep.
These values don't reflect what might be realized upon a sale and so forth.
But what about the Attorney General's point that may be true in this case, but we are trying to create a fair and honest marketplace, which will inure to the benefit of the public in the long run.
Yeah, and I would say 2 things in response to that. First, all the questions about line drawing. If this case falls on the other side of the line, there is no line. I mean, you heard, I think, for 15 minutes, respectfully, my colleagues struggle to articulate any clear principle that would put any transaction outside the reach of the statute on the Attorney General's very broad and sweeping view. So our position is narrow, which is that on the facts of this case, all these things I've referred to, no reliance, no materiality, Deutsche Bank saying we would have given them the exact same deal, and we have clear disclaimers. Surely this is not within the statute. And if this is, there's nothing that falls outside of the statute. Right. And that is a sweeping and unsettling thing. The second point I'd make about that is...
And I'm sorry, just to tie a ribbon around that, do you mean based on the facts as they were adduced on the respective records, the summary judgment motion as to cause of action 1, the trial record as to 2 through 7? Yeah. Not that the AG didn't have an interest, at least at the outset, in investigating and maybe commencing the proceeding.
We're not disputing that in this.
They certainly have that interest.
You're saying once you got all the facts before the court,
and that may have been, I wasn't on that case, but that may have been the point of our prior decision, which Mr. Isaac brought up about this being at the pleading stage. Yes, so it was enough at the pleading stage, but at the end doesn't mean this is what should happen.
That's exactly right, Your Honor. Here we have all the facts before the court.
But the pleadings in this case, but the pleading in this case is like a novel. It goes on at length, 327 pages or something like that. And basically those were the facts that Justice Engoron found were proved at trial. So
Very,
aren't we bound by our prior decision? I asked this question another way before.
very significant variations. I just want to flag one. I see my red light is on. The pleading, the complaint, cites GAP like 50 times. They said these statements are bad because they violate GAP. But you go to the summary judgment record, they have nothing. They don't put anything on GAP. The trial court never cites GAP. Our experts say these are GAP compliant. That's unrebutted. So there's this totally, the record looks totally different once all the facts are in. And I know my time has expired, so I thank the court for its time.
Thank you.
Good, well argued.
I'm actually going to go under my time. I just have one observation.
We'll get to that one, Kralik.
And I don't know, maybe I'm wrong about this, but this argument, if it doesn't show why not making a summary judgment motion was appropriate, I don't know what is. There was absolutely nothing wrong with what the attorneys did. My adversary said that she's relying on the Ernst & Young case. I read to you what you said. That's exactly what you did. One more point and I'll sit down. Keep relying on Greenberg. This is what the Greenberg court said, Greenberg 2. Initially, we note that defendants may not raise issues on appeal that were not preserved on the record for our review. So even if they're right about what this court said and they're not right, it wouldn't matter anyway because lawyers have to preserve issues for all courts that may consider it. They have to look at things not temporally at the time, but what could happen afterward. And given that, and this isn't Brian Isaac or it's not Michael Ross, I'm reading to you from the court. They did what they were supposed to do. They did what they had to do. To sanction them is just wrong.
Thank you.
Thank you.
Please rise.
Good. Yeah, the answer
that's
there
it.
is that
Yeah.
the answer is the judge's rule.
It's their court
The
rule.
oral argument is for the benefit of the judges. And so you heard that opening question where it was more of a statement. What the judges, they've come back in, they've discussed the case. They know what their colleagues are doing. They know where, like, I counted 2 votes for Trump. Now, I counted maybe 1 vote against Trump. So, so there might be a swing vote or two, maybe. And let's just assume this for theoretical purposes. So, so what happens is the judges are asking questions to try to convince that judge to come over to their side. The oral argument is really not to be convincing the judges except through their direction. It's a tool because the judges could spend all their time lecturing the attorneys there and give them no time to argue. There's no right to orally argue, nor is there. There's, so it's really at the
sometimes that
pleasure of the
happens.
judges. Oh yeah.
Sometimes
U.S. Supreme Court arguments all the time.
Yeah. And guys, we listened to the Vanderstock case. Depending on the situation, those justices will, that one was very orderly. Justice, so-and-so, do you have questions you want to ask? Sometimes they have every right to jump in on each other. These judges could have, like this one here, the judges jumped in when they had a question. But sometimes I've had arguments like that where all it is you are under assault for 10 minutes.
Yes.
And they are just, and it's not even that you're getting lit up. It's they have questions about the case
that
they want you to explain and clarify.
One of the cases that was like that, the Jaquel Davis case before the Florida Supreme Court that I did, you're supposed to stop talking immediately when there's a question. And the judges kept firing questions. Different judges kept firing questions at me. And every time I'd have to stop mid-sentence to answer okay, listen to the question. And then I'd start to answer, then somebody else would chime in. And so my argument I thought was very disjointed in that. The briefing was strong, but it's because I have to shut up when they start talking.
Yes, you have to. And guys, here's the one thing I will tell you. Oral arguments sometimes can be used as an indication of how things are going, but don't just rely. You are a fool to rely on that only, because that's not the ultimate. The ultimate thing is when they're back there discussing it. That's what matters most. And then ultimately what they put down on paper is what matters most. So while this is helpful, and I'm sure it's neat to see that, this lady get BTFO'd, sometimes you get BTFO'd and you win.
Yeah.
And there's so many times appellate attorneys will tell you, "Oh, I had it in the bag," and then you get felted.
Well, a lot of times what'll happen, I mean, the older I get, the less I'm impressed by oral arguments.
Yeah.
Because to me, the written, like you said, the written word is under control. And we had a statement when we were in the public defenders is like, you can only lose your case on oral argument. Because what happens is the judges know what the argument is behind the curtain. And so when your friendly judge says, well, counselor, you would concede that, and then they lay out their little fact thing, and then it's some area like, oh yeah, well, yeah, that's not my argument. My argument's over here. And you just conceded the point that was in discussion behind the curtain, right? So you can lose a case, but you can very rarely win the case. You win the case on the briefing and the facts.
Yeah. And Irish is saying, I kind of sense they wanted her to convince them. No, it's just, the problem is this case is strains credulity. Even for them, they're like, this makes no goddamn sense. Why are we doing this again? They're like, the
elephant in the room is because the AG is out to get Trump and he wants to destroy him.
Yeah. And, very much. And, yes, it's very much, I don't know if you did, I don't think you were on when we watched this. It was the Indiana Supreme Court. It was a case that's about to go to trial. The judge kicked 2 attorneys off of the representation of a defendant, and they filed a writ of mandamus, and the Indiana Supreme Court immediately heard it. And the judge and the the Indiana Attorney General's office were arguing United States v. Wheat. And the Supreme Court asked them, like, do you have any other argument besides Wheat? And they're like, well, no. And the attorneys got put back on the case. It was very humorous. Now, I'm not telling you guys, it's going to be a surprise. But yes, that was better. Certainly you want to come out of it looking better. I think Sauer looked better. He had a better argument. And yes, the judges weren't, saying like, oh my God, why are we doing this to him? They were looking at the Attorney General saying, you need to explain to us why at all this should be justified.
Well, I do like the judge's take that where in the argument about where is the limitation on this law, and that is it's these type of statutes, any governmental assertion of power needs to be strictly construed, because once you have some statute or something that can be broadly construed and applied to everyone, then we're all at danger. We're all at risk. This is, I've tried twice before to get 2 of my SCOTUS cert petitions were on the obstruction of justice statute in Florida. And because I am of the opinion that the obstruction of justice is a criminal catch-all, and that there is no basis for a criminal catch-all in the law generally, and especially the way it's applied. It's basically contempt of cop. And I've tried to get that in front of the court, and I think I'm right on that point, but it has yet to be, and I probably won't get to address it, but that's the kind of thing that we're all in danger of. You interact with a police officer who is an executive, and they start pushing you around, and you say, but I didn't do anything wrong. Well, I'm ordering you to do X, Y, and Z, and you didn't listen to me, and so now I'm arresting you for obstructing justice because I'm justice, and now you're a criminal because you're disagreeing with a cop.
Yes. Exactly. Okay, so we got super chats here. Steve, I know you said it was late, and I know you're a little tired. So if you want to stick around, you're more than welcome to. But I know you've.
No, it's okay. It gets me energized when I'm talking.
Oh, good. I'm glad. Just didn't want to make you feel like you
I appreciate that. No, I'm feeling pretty good.
Good.
But thank you. I've been working really hard.
Oh, I bet.
Civil law, it's like nonstop, and so I haven't had the energy to go on streams and do stuff or do streams or really even think about it. I'm just sort of goofing off here at night, and
it's got to be nice though, relaxing.
There's very little. I have very little free time. Yeah.
So President-elect Phil Sfuss says, Tim, I totally shoot guns and fought in wars walls. Yeah. I don't know if you saw the video of him on Twitter where he's like struggling with a shotgun. Yeah,
so
kind of funny.
I mean, we're way past the age in media with YouTube and the content wherein somebody goes, is this for get me a hunting license? And all the rednecks fall in line. Oh, well, he's a hunter. He must be on my side. I mean,
but that's all they know.
So stupid.
Colostomy Bag says the chocolate French make bad guns. No, the Italians do pretty good. The Italians make pretty good guns. Some of the oldest gun company in the world is Beretta. It's one of the oldest corporations in the world. 15, like 16, I think, or 15, actually, like 1526, actually. Colostomy Bag says, what's the mouthfeel on a 12 gauge 870? No comment. Jefferson Post says, Cape Cod is similar. Most of the value is in the land. Yes. And Phil Coggins, been a member for 5 months. Thank you, Phil. Yes, a lot of vacant lots with a Mar-a-Lago within a half mile are 20 to 50 million. Yep. Julio says, mute this bitch. And did she scoff at the judge? No, because if she had scoffed at them, they would have been like, excuse me, like that. They would not have let that go. SB Seller says, for the Pebbles Destroyer Toast Fund donation. Thank you, Sellers. Boosh McFadden's a new member. Thank you, Boosh.
Oh, hey, Boosh. Boosh is a good guy. I love Boosh. Thank you,
He is a very
Boosh.
good guy. Golden Mongoose says, why didn't Trump's lawyers say the magic words and ask for a Frank's motion? Frank's hearing. I don't know. I don't know why they didn't, chat. That's, was so easy and obvious. And Dr. Mimo is saying, it's good to see you. It's been a little while. It says, I'm begging y'all, stop doing business in New York. You're not safe there. Yeah, but New York is the center of finance and everything, so it's probably not going to go away.
Though I hear Texas is putting together their own stock exchange. I wish Florida would do that.
That'd be fun if it took it away from them. J-Rock is saying, Sean, with inspiration from SB Sellers, toast my dog, Sean. Why won't you toast her, Sean? Answer the question.
Well, there's inside jokes going on that
They want me to toast J-Rock's this dog who died, Pebbles.
Oh, well, why don't you toast the dog? That's nice. Why don't you toast him?
Because they're being assholes is why.
Okay, I don't get on.
Yes. Nisa Natic is correct, though. You can't just put a dog in a toaster. That's really mean. I agree. Anderson Cooper says, felony child abuse, 5,000 nanograms per liter of cocaine metabolites. Yeah. Yes.
Oh, I see that. People are yeah, I know. You're in the dramas. I'm not in the dramas.
Yes. Rod Breton says, why does New York call a non-Supreme Court the Supreme Court?
It's just one of those, it's one of those things in law school they like to screw with you with is Louisiana civil law and New York screwing with their appellate names. Yeah.
This goes back into the 1800s, like early 1800s, Rod, and even the 1700s. This is not something new. This is a very, New York's one of the older colonies anyway, so that's something that's just going to be there. That's something that's just going to be there. So I don't have an answer for that. Dr. Mimo saying, yes, basically the whole thing is show me the man and I'll show you the crime. That's exactly what they're doing here. We've 100%. I don't disagree with you at all. And J-Rock saying, yes, he's talking about the secured overnight financing rates. So that's kind of how it's tied to treasury. I think it's tied to like treasury securitization, I think. I forget the top of my head.
I don't know. J-Rock sounds pretty sophisticated.
He is. He's pretty.
I'll defer.
Yeah. He says, and he says, yes, and it's trying to explain it, guys. Yes, if client is worth $21 million, his rate is going to be, plus 4 points. And client B, he might get it plus 3. And yes, the amount of money you have, the more you're worth, the better rates you get. Because you're less of a risk and they can get it back. Stephen Cooper says the writ of Matt Damon. No. Jeez. Oh, Fatty Caddy says, what are your thoughts on stripper poles in churches?
Yeah, he's trolling me or something. Well, people say I should be offended. I don't get offended by stuff. When you do criminal law, the stuff that you see in criminal law is pretty darn offensive. When somebody says stuff to troll you or to get you, poke you, when they screw with your livelihood, that's pretty offensive. I'll tell you that.
Yes. And Colostomy Bag saying the chocolate French are Belgians. Well, Fabrique Nationale is a very good gun company, so I don't know what more you'd want to say there. They make good guns, although you're going to argue that, John Browning made one of their really good guns and he, a bunch of their good guns, he wasn't Belgian. And then, Dieudonné Sauvé, I think he was French. So yeah, you could argue that the FAL was made by a French guy too. So I guess you're right. J-Rock says, maybe Steve will toast Pebbles the Destroyer.
Pebbles the Destroyer?
His dog, Pebbles.
Oh, well, toast to Pebbles the Destroyer. How's that? I don't know what that is, but...
Oh. So yeah, guys, let's see where you guys else you guys got going
Pebbles
here.
the Destroyer. That's the name
Yeah.
of the dog. It's pretty
Yes.
funny.
Rusty Heckler is correct. Yes, but Orange Man bad. Yes, the Orange Man's so bad. I'm also offended Sean didn't read my entire handle. I'm sorry, Anderson Cooper, 360 no scope.
Yeah, like people. Did you see the Dorito Communion thing by
Yes.
Gretchen Whitmer?
Yes.
You know, but see, I don't get that stuff. I mean, being offended, I don't know. I mean, it's kind of one of those things. It's like, does that
she's
affect-
she's everything she does is offensive. So it's like one more thing to get offended about. Like,
Well,
like
mean,
I
it's
said,
like, am I going to spend my life being offended at what everybody in the world does?
yes.
I mean, it's.
Mm-hmm.
I don't know. My offensive. I don't know. I don't know.
I still give Gretchen Whitmer credit because she is a very, like, every time she goes on TV, she's got that very oily appearance. Her face is real shiny. And I think it's very interesting because I'm a fat guy and I'm not that oily. But Gretchen Whitmer, like, she's just an oily girl. And she didn't look very oily and nasty in that video. So it's like, I guess that's one thing she did right. So
yeah, it's just strange. And I mean, you know,
yes,
I just think there's too many people that are getting offended by too many things, and they're going out and seeking ways to be offended. You know, if people target you specifically, if they're trying to offend you specifically, you know, and I don't know, reading somebody's intent. Generally, people don't try to be offensive to you. You know, usually people are goodwill, and like even I know that what that's referring to. That was referring when I was on that show, the other show, you know, that you're at war with or whatever. But
I'm not at war
I mean,
with it at all.
Well, whatever it's going on the drama there. But I mean, it's like to me, was that meant to offend me, or was that meant to just poke at me to have fun? Is it a joke? I don't know.
That was more of a comment. Somebody was asking for you to make a comment to rile someone else up.
Yeah, exactly.
So that wasn't meant to offend you. That was meant to ask you a question you'd answer, which would then make someone else angry.
Yeah, you know, this is the thing. I mean, just
so you were being used as a vehicle.
What else is new? That's my life.
Well, J-Rock says Steve is greater than Sean. Suck it, Sean.
Stop it. Actually, Sean and I mean, I one of the reasons Sean and I get along is because this is a real practicing lawyer guy, criminal lawyer, and you deal with the same stuff, and you know what I'm talking about being offended. I mean, the crimes when you have to watch those videos and murder and death and destruction and all this stuff, it's like, and then somebody says a dirty word, I'm like, I'm not offended. Right? Yes. I mean, I don't want, but I choose not. I try not to say dirty words, and I try not to commit violence or whatever.
Exactly.
But it doesn't mean. But that's who you are and how you react is who you are. Anyway, I don't know what I'm talking about.
No, you're fine. You're fine. And Aaron Hack says Steve's house looks like Joe's house.
Yeah.
You guys both use the same backgrounds.
Yeah. Well, it's the only one because we're too cheap to buy an extra one or something. I don't know.
Well, I don't know where are you using to show the background? Is that through StreamYard or what?
Yeah, it's just
it is.
Yeah, I can use the virtual. I only have like two.
Oh, virtual back.
Oh, there's that one, and there's that one.
There's
and there's that one.
I can do it too.
That's the only.
Here we go. We're roommates, chat. We live together.
Yeah, and there is, you know, one thing is there are people that are just malicious and evil, and you know that is true. But how do you respond to evil? That's a question we all have to confront. You know, if you respond in kind, then it's evil's winning to me. I think that you really have to be careful on how you respond to things, even when you're subjected to, you know, falsity and tyranny and personal destruction. You know, Job has a lot of wisdom there. I don't know. I mean, I don't know if I try to overcome things, but we're always being tested, right?
Very true. Very true. And Katie says, Steve, will you go play the piano for us? Okay. Yes, Stack says the Godfather.
The Godfather, Zach. Hey, Zach, good to see you. Yeah, I'll tell you the thing. It's some really nice people in chat. I met a lot of nice people on the internet. I've also picked up some real haters and trolls who are out to get me. But finding that balance would be nice.
Yeah, well, you're gonna find no matter what you do ultimately. Yeah. So, all right, guys. Well, I think we're all caught up here. Yes, ultimately, do I think Trump will win this argument? I think he has a lot of good arguments. Yes, but remember, this is not going to happen before November, and it's almost like it was designed that way. Just a thought. It's almost like it was designed that way to not matter until after the election. But I think he will persevere here, and God willing, he persevere. And I'm starting to feel a little better. I was dooming for a while, but I think he's going to win in November, which will make it even funnier. So,
I hope so. Boy, I'll tell you, we're in danger.
Yes, we are.
You're in great danger. Yes. I love that scene.
Yes. And Ag says, are we going to do some model tonight? Yeah, we're going to work on this. I need to, now that paint's dried, it doesn't look as bad. So we'll work on that a little bit more. So, and speaking of J-Rock, here's what it looks like. It's looking pretty good. It's all good. Don't worry, buddy. We're getting there. So, but yeah, we'll give me like a couple minutes and we'll put that together. So, Steve, do you have any other things you want to tell anybody in the meantime?
I haven't been able to come on or do stuff because all of my energy and focus is on learning a new, civil law and civil criminal or civil defense, not doing criminal. I am revising. I am doing, and the extra time and energy I do have, I'm putting into revising and kind of cleaning up some of my books. And so I'm going to come out with a third edition of Ideas and Answers in Law, in which I'm going to include 2 new chapters on some of the things I was working on at the Miami-Dade State Attorney's Office, and I'm converting them into 2 chapters. One is how for a prosecutor should stay out of trouble by when they prep witnesses for depositions or trial, which is, as a defense attorney, we often see, prepping as in telling them what to say. And that's a big problem for unethical prosecutors. So I've got a kind of a little handbook with a form for people to use on how to do it properly and how to, it's kind of an interesting thing. And then there's another chapter on inadvertent disclosure of confidential information. So how should a prosecutor handle, say, like a jail phone call that they accidentally overhear, or a warrant that sweeps up attorney-client interactions. So these are policies for prosecutors' offices that I think would be interesting for you as a defense attorney and anybody in criminal. So anyways, so I'm going to add 2 chapters. I'm also cleaning up. I've got this thing called Grammarly, and I'm going through my entire book and cleaning up all the grammatical errors. It's amazing. These are law review articles that they're still screwy. So it's a lot more active voice, and I'm trying to make it more readable. So anyway, that's all available on pre-order now, and you can get old ideas, 2nd edition Ideas and Answers in Law without those 2 chapters. You can get it on sale at my website because I have some stock that I need to sell out. So please do go over, Steve. And of course, Prepare is the book y'all need to get. That's the one that has all my philosophical musings.
Yes, Prepare is very good, guys.
Thank you. Oh, did you read it? Tell me what you think.
Yes.
Prepare?
Yeah, I did. Yeah, I thought it was very good. I thought it was very nicely done.
Yeah.
I mean, I also appreciated, your legal books, but yes, I thought Prepare was very good.
Thank you. And just all the different stuff we've got, and it's all my stuff's now available on Amazon, except for Brucey, the one-eyed wonder dog. So you can. I'm trying to again, I'm getting away from it. I'm getting away from a lot of the things I'm doing, but I do still appreciate buying my books. Please do.
Are you eventually going to get Brucey on Amazon, or?
It's too expensive. The problem is I'm sold out.
And because it's color. Yeah.
Yeah. And I'm sold out of Brucey. And in order for me to make any money on that, it's basically I have to buy 120 of them. And I'm selling like 3. So I can't take it. So they're sold out. Now the coloring books are available, and I just reordered some coloring books because they're a lot less expensive. But I can't reprint Brucey. I'd love to, but until I get stabilized and stuff, I mean, that's a $2,500.
Yeah, that's
purchase.
A lot of bucks to hold on to.
I can't spend $2,500 and then have 125 books sitting on my around in my little 900 square foot apartment.
No, that makes sense. That makes sense. So,
but anyway,
all right, guys. Well, at some point we will see Brucey on Amazon. Just not right now.
Maybe not. Probably not. You can get Brucey. You can get Brucey the coloring book at stevegosney.com.
No, there we go. And
the
guys,
rest of my books are on
Brucey's
Amazon.
a great book, by the way. Little kids love it. So, in the meantime, guys, all right, Jesus, nothing. Skip says, "What does Steve think of Wilshire Boulevard?" I
don't know what that means.
Don't worry. That's a funny joke. It's a book that we'll never get to read. Anyways, guys, take care. Enjoy your night. Give me a couple minutes. We'll start working on the model. But in the meantime, Steve, thank you so much for being here. I appreciate your time.
Thanks for the invite. It was fun.
Steve Gosney, everybody, and we'll see you guys later. Take care, guys.
Bye-bye.
Yep. Bye now, everyone.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy that Kaden yelled at? Why, yes it was. He even knows he's